Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of the Senate, and deign to assist us in the duties that we have to perform on behalf of the people and our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation. Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Leroy Batiste, who is out of the country. Honorable Senators, I have received correspondence from Her Excellency the President, Christine Carla Kangaloo, ORTT, advising of the following temporary appointment in accordance with Section 44 of the Constitution. Mr. Ashworth Jack, during the absence from Trinidad and Tobago of the Honorable Leroy Batiste. Honorable Senators, a senator is required to take the oath. May we all stand?
I, Ashworth Jack, having been appointed a Member of Parliament, do affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago on which I am now about to enter.
Petitions, papers.
The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Thank you. Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The unconsolidated audited financial statements of the Trinidad and Tobago Electricity Commission for the year ended December 31st, 2024, and the unconsolidated audited financial statements of First Citizens Holdings Limited for the financial year ended September 30th, 2025.
Motion relating to the business or sittings of the Senate and moved by a minister.
Mr. President, having regard to the following: one, that the Retrenchment and Severance Benefits Amendment Bill 2026 was passed in the Senate on April 24th, 2026. Two, that the Victims' Rights Bill 2026 was passed in the Senate on May 15, 2026, and three, that both bills were forwarded to the House of Representatives for concurrence. I beg to move that this Senate request that the House of Representatives restore both bills to its order paper in the second session of the 13th Parliament.
Honorable Senators, the question is that the Senate requests that the House of Representatives restore the Retrenchment and Severance Benefits Amendment Bill 2026 and the Victims' Rights Bill 2026 to its order paper in the second session of the 13th Parliament. Those in favor say aye. Those against say no. I think the ayes have it.
Public business, government business, bills second reading.
The Leader of Government Business and Minister in the Office of the Prime Minister.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Deoxyribonucleic Acid Act, Chapter 534, be now read a second time. Mr. President, we live in perilous times, and terrorism poses a constant threat to the security and stability of all nations, including Trinidad and Tobago. We exist in this time where that threat of terrorism requires all countries to devise countervailing measures to protect their citizens from persons, entities, and organizations who wish to carry out acts of violence with the intention of either coercing governments and suppressing or otherwise intimidating the public. And these dastardly acts of terrorism these coward acts of terrorism are often carried out under the guise of advancing political, ideological, religious, philosophical, and other similar agendas. Mr. President, as a responsible government, we cannot bury our heads in the sand to these global realities, the realities around us. And we must rise as a nation to meet them and to combat this rising plague of terrorism. And there's one tool in our arsenal, which is legislation. Mr. President, the prevailing theme of our national anthem is that of unity, equality, harmony, and partnership, irrespective of our varying backgrounds or beliefs or the causes that we deem important sometimes. We have the line in our anthem, "Here every creed and race find an equal place." And I say find because I'm a purist, and that is what Mr. Castani wrote for us, find an equal place. Some persons feel that here every creed and race, they is in brackets, and it's understood they find an equal place, but that's a debate for another time. So I won't terrorize you all with that. And we also have our national pledge, which we all knew in primary school. I will strive in everything I do to work together with my fellow men of every creed and race for the greater happiness of all and the honor and glory of my country. And I reflect on those things, Mr. President, because they all are consistent with our fundamental human rights and freedoms which are enshrined in our Constitution. And the preservation of those rights we must passionately uphold and defend. And they're everyone's rights. There's always a balancing act. The Office of the United Nations High Commissioner for Human Rights highlighted in a document entitled Human Rights, Terrorism, and Counterterrorism, the relationship between terrorism and human rights, if you want to call it that. And I quote, "Terrorism clearly has a very real and direct impact on human rights, with devastating consequences for the enjoyment of the right to life, liberty, and physical integrity of victims. I continue to quote, Mr. President. In addition to these individual costs, terrorism can destabilize governments, undermine civil society, jeopardize peace and security, and threaten social and economic development." And I continue to quote, "All of these also have a real impact on the enjoyment of human rights. Security of the individual is a basic human right, and the protection of individuals is, accordingly, a fundamental obligation of government." I continue the quote. "States, therefore, have an obligation to ensure that human rights of their nationals and others by taking positive measures to protect them against the threat of terrorist acts and bringing the perpetrators of such acts to justice," unquote. So I wish to state that when we speak about human rights, we're speaking about the rights of everyone in the society, including the victims of terrorism, and also the integrity of the state to protect its individuals. We make laws here for the peace, order, and good government of Trinidad and Tobago. Mr. President, one of the realities that confront us as a nation is that nationals of Trinidad and Tobago have traveled to areas regarded as conflict zones, such as Syria and Iraq. And some have returned, and others desire to do the same, to return to Trinidad and Tobago. The further reality, Mr. President, is some of those individuals have traveled to those areas for the distinct purpose of committing terrorist acts as defined under Section 15A of the Anti-Terrorism Act. And I want to, at this point, read the definition, or at least the material part of the definition of terrorist act from Section 15A of the Anti-Terrorism Act, Chapter 1207, which says, a person who knowingly and without lawful excuse travels for the purpose of A, planning a terrorist act, B, committing a terrorist act, C, supporting a terrorist act, or D, facilitating the commission of a terrorist act, commits an offense, etc. And for the purpose of this section, support includes, but is not limited to, A, an offer to provide or the provision of expertise or a skill, B, an offer to provide or the provision of documents, and C, entering or remaining in any country for the purpose of committing or facilitating a terrorist act. So let's mark that spot. So that gives you an idea of what constitutes a terrorist act from the Anti-Terrorism Act. Mr. President, among those persons that I have spoken about, there are also persons who wish to return to Trinidad and Tobago from some of those countries, such as women and children, who, while they may not have been involved in the commission of terrorist acts, they have been exposed to radicalism or may very well otherwise have been affected by their association with international terrorist activities and groups. And that's something that we have to appreciate. The statistics have revealed that over the past 2 years, 6 persons have returned to this country from conflict zones. 2 of which were adults, and the remaining were children. And Mr. President, whereas some provision has been made in the Anti-Terrorism Act, which was last amended in 2019, it's a 2005 act, which was amended over the years, 2019, to address in some measure the scourge of terrorism. The Anti-Terrorism Act, in our respectful view, and others, do not adequately address the issue of repatriation of citizens from conflict zones or areas which that may be declared geographically as zones where terrorist acts have occurred or are occurring as we speak. In fact, Mr. President, we all know that sometimes legislation has to catch up with reality. And while in the interest of national security, we say the current legislation in the existing DNA Act makes provision already for non-intimate samples to be taken from persons returning to this country as deportees. Without their consent, that act does not provide for the taking of samples from persons who are foreign terrorist fighters and returnees. And those persons, therefore, were therefore permitted to reintegrate into society without any biological record being obtained. This underscores, Mr. President, the pressing need we see for this legislative gap to be addressed and to be closed, and to provide for the taking and storing of DNA profiles of persons returning from conflict zones who, on evidence, they present a threat or risk of committing a terrorist act as defined in Section 15A of the Anti-Terrorism Act. And it is as an aid to the measures deployed and that are to be deployed by the state to safeguard, at the end of the day, all of the citizens of Trinidad and Tobago. That is the aim, Mr. President. And we say it is a legitimate aim. And how do we propose to meet that challenge, Mr. President? We want to, first of all, expand Section 16(1) of the existing DNA Act to include two types of persons generally. Namely, first of all, what we would call a foreign terrorist fighter, and secondly, what we would call a returnee. Now, if you look at Section 16 of the DNA Act, it is the section that provides, and I'm reading from the marginal note, non-intimate sample to be taken from deported citizens. And that is the section that we want to amend. We want to include or expand 16(1) to include these types of categories. And what is the method we have used, Mr. President? We have tried to be consistent and not invent a fresh definition for a foreign terrorist fighter. When we speak to terrorist acts under Section 15A, which I've already mentioned. So we have not rebuilt the house. We have stayed consistent to the type of activity that would raise a red flag. And what we say is, first of all, the foreign terrorist fighter, which we are tacking on to 16(1), a person will be deemed to be such where he knowingly and without lawful excuse travels for the purpose of planning, committing, supporting, or facilitating a terrorist act. And that is in harmony with Section 16(1) of the DNA Act. And we want to bring it into, and what we want to do is, while we've expanded, or we are expanding 16(1), we are plugging in two definitions in the definition section to work with the expanded 16(1). And you would see it in the bill, Mr. President. Foreign terrorist fighter and returnee. So that 16(1) would read, where a citizen of Trinidad and Tobago is deported from any place outside of Trinidad and Tobago, and that is the deportee situation, and we are adding the words, or is a returnee under Section 4, which will be the definition that we want to amend to put a definition for returnee, or is deemed to be a foreign terrorist fighter under Section 4. Now, the term returnee has not been defined in the Anti-Terrorism Act. However, we've tried to be consistent with some of the working papers that we have, because there is a returnee bill which is still under legislative review. No doubt somebody will say here that they drafted that, but We've taken that definition of a returnee. We've returned to the returnee that was drafted. Anyway, let's not go there. Now, based on this, Mr. President, I said there were two categories, the foreign terrorist fighter, as well as the returnee. But the returnee has two categories of persons. It will firstly relate, and this is straightforward, to a person who is entering from a declared geographical area as defined under Section 2.1 of the Anti-Terrorism Act. So if you're returning from that particular area and terrorist acts have occurred or are occurring, and if you were detained in a facility, camp, or place of detention in that declared area, it would apply to you as a returnee. Which is different from a foreign terrorist fighter. So in this particular case, you had to be in the area, and acts would have been occurred in that area, terrorism acts, and you were in a facility, camp, or place of detention in that particular area. Okay? It will also apply, Mr. President, and that's in clause, so I've dealt with clause 3A. We also have clause 3B of the bill, which is the second category of returnee. So basically it's three types, but we have one type, which is the foreign terrorist fighter, and we have two types of returnees. So we have three different types of persons. The second type of returnee, Mr. President, is under clause 3B, and I will read the clause, who the minister with responsibility for the Anti-Terrorism Act, i.e. the Minister of Defense, has reasonable grounds to believe poses a threat or risk of committing a terrorist act and who is not a foreign terrorist fighter. So the minister must have reasonable grounds to believe, based on intelligence and security assessments that he has received, that that person poses a threat or risk of committing a terrorist act. Now, that power that is given, we say respectfully, Mr. President, is not absolute, but is actually a very qualified power by the inclusion of the word reasonable grounds. It's what the police can do when they can arrest you on reasonable grounds. It's not a phrase unheard of in our laws. And what it means, Mr. President, is that the power cannot be exercised arbitrarily, capriciously, prejudicially, or on a whim. All of these are judicial review grounds. But it must meet the legal threshold for reasonableness. And in the interest of national security, and ordinarily, actually, under the Immigration Act, it happens, because there's actually a very wide discretion under the Immigration Act to detain anybody who comes in, including citizens who come in and say, I have a right to be in this country under Section 4.1 of the Immigration Act. Well, you have a right to enter, but immigration can detain you. So this is consistent. So this person, this category of returnee, the second category, would be detained upon arrival. And to take a non-intimate sample of DNA. Now, under Section 13.1 of the DNA Act, this already happens, and provision has already been made for non-intimate samples to be taken without the consent of persons who have been detained, so that these proposed amendments before the Senate today would work in tandem with the legislation. Now, what are non-intimate samples, Mr. President? And both intimate samples and non-intimate samples are defined separately in the DNA Act. An intimate sample, as opposed to non-intimate, refers to a specimen of venous blood or biological or other material taken from A, any part of a person's genitals, or B, a person's bodily orifice other than the mouth. and that therefore intrudes into a person's bodily privacy. However, the situation is different. A non-intimate sample, which is what we are dealing with today, we want to take non-intimate samples from returnees and foreign terrorism fighters, refer to a specimen, and this is from the DNA Act, a specimen of A, blood obtained by a pinprick, not a small pin center of us, a pinprick, okay? Or B, epithelial cells obtained by means of a buccal swab. In other words, a swab on the inside of the cheek. Buccal swab, sorry, buccal. Plucked hair. Or saliva. So these are non-intimate samples. Yes? And let's pay attention. And these samples do not intrude, Mr. President, into a person's bodily privacy. And we say, Mr. President, that as such, there is no need for any special or 3/5 majority in favor of this amendment, as was required for the passing of the original DNA Act. A simple majority would suffice. We all know the law has changed since the DNA Act was passed. Surat, Suraj, we are pursuing a legitimate aim, and we are taking the least intrusive measures. This discussion would have been different if we were going for intimate samples. But we are looking at non-intimate samples, and we are looking at taking those samples when they arrive at the border. Non-intimate samples, when they arrive at the border. Because that's the only opportunity we may have. Because if, for example, and I know this may come up in the debate, that you want to go before a judge in chambers and get an order and judicial involvement and that sort of thing, by that time the person will be complaining about a very long detention, or the person may very well have left the airport or the seaport and we can't find them again. So this is a special type of legislation, national security, and I would like members of the Senate to appreciate that this has to do with border security, precautionary measures, and a building of a DNA database for persons who ought to have their DNA there so that it will assist in the detection of crime, including offenses under the Anti-Terrorism Act, and also to assist in we acknowledge our participation in combating terrorism in the global environment. I'll put it no higher than that, global environment. Now, what are the mitigating factors which make this reasonable and proportionate as well? So I've spoken about the fact that it's non-intimate, it is a legitimate aim required, and it's least intrusive, literally least. In fact, it's not intrusive in the sense of the word. It's least intrusive. You're not going into cavities and offices and so on. You're doing a pinprick. Not a small pin, a pinprick. Okay. Well, you need a small pin to prick. Anyway. Now, what are some of the other mitigating measures that help to counterbalance the weightiness of what is happening? First of all, non-intimate samples will not be retained indefinitely. And we don't need an amendment for that. That's in the DNA Act as it is now. Within the current legislative framework, Section 25(1) of the DNA Act, samples are to be retained for a minimum of 5 years from the date the forensic DNA analysis was completed, and after this they may be destroyed. Persons who are affected, who feel that they have their DNA in there and they feel for some reason they want it expunged, they can make an application under Section 26(5) as complainants to the Commissioner of Police for their DNA profile to be expunged from the forensic DNA data bank. In such a situation, once the Commissioner of Police, after consultation with the Director of Public Prosecutions, holds the view that the retention of that DNA is no longer necessary, or in relation to a matter either under active investigation or a matter that is currently before the court, the DNA profile will be expunged. And of course, persons may also, if they consider themselves aggrieved by any aspect of that process of application to expunge, can approach the court for recourse as remains within their entitlement. And in fact, let me walk back a bit as well, that I know in the other place there was some concern over the minister, first of all, being given the responsibility to deem a person as posing a threat or risk of committing a terrorist act who is not a foreign terrorist fighter. And I want to dispel two arguments in advance. First of all, the minister is the first port of call, obviously, at the border, where quick action needs to be taken. Secondly, the minister's discretion is circumscribed. And unlike what has been said what was said in the other place, which was corrected, the minister is not deeming anyone a terrorist for the purposes of the Anti-Terrorism Act. He is not a court. What he is doing is deeming the person as falling within a person who may commit terrorist acts for the purposes of the DNA Act, which is an administrative deeming in order that you can take the non-intimate sample. So it's what we call referential legislation. So we are taking the definition from the Anti-Terrorism Act. We are not amending the Anti-Terrorism Act. We are amending the DNA Act, borrowing the reference from the Anti-Terrorism Act. Now, Mr. President, once this bill is passed, and we hope it would be, and becomes law, it will effectively address that legislative gap that I have mentioned. And with respect, we say it would enable non-intimate samples to be taken without consent, needing to be procured first from persons entering Trinidad and Tobago from conflict zones where they served as foreign terrorist fighters or were otherwise detained in such zones. And it will also enable non-intimate samples to be taken without consent from persons returning from other areas where, based on the evidence and intelligence, there are reasonable grounds to believe that such persons pose a threat or risk of committing a terrorist act. In so doing, Mr. President, we anticipate that the evidentiary basis for any related criminal investigation, if there is any to come out in relation to any of these individuals, if that evidentiary basis will be fortified significantly. And this law, operating in tandem with other laws, national security and criminal justice capabilities of Trinidad and Tobago will undoubtedly be bolstered in that regard. So we want to strengthen both our borders, our border security, and the way we detect and prosecute crime. Yes.
Just want to seek your indulgence for a moment. I know the students understand I'm going to leave in a short while, and I didn't want them to leave without members recognizing which school they are from. So at least we'll have that for the record. And I'd like you, that is all members, to join me in warmly welcoming students and the teachers of the Upper Kaipuchaima Presbyterian School to the Senate. You may continue, Senator Allahar. Sorry to interrupt you.
That's again my pleasure, Mr. President, and we welcome our children to this debate. Mr. President, as I said before, this bill will cover, or is expected to cover, adults as well as children. And I want to put my colleague senators' minds at ease, because within the DNA Act, I know, Senator Murray, you are very concerned about children and about process in relation, as we all should be. We have children today. And I would like you to look at Section 21 of the existing DNA Act. And it says, where a sample is to be taken from a child or incapable person under this Act, the sample shall not be taken unless the representative of the child or incapable person is present when the sample is being taken. And subsection 2, you have to fill out a form and that sort of thing. So the law has already made provision for what happens when samples are taken from children. And that's existing law. So what we are doing, again, legislative convenience, we are building into what has been there before. So there should really be no worry, because we're not inventing anything new. And in fact, we go on, that same 21 deals with incapable persons, which the definition in the DNA Act, Section 4 says, incapable person means a person who, by reason of his physical or mental condition, is either unable to indicate whether he consents or does not consent, or he's incapable of understanding the implications of consenting or not consenting to the giving of a non-intimate or an intimate sample. So I just thought I would segue into that. I have 7 more minutes. So I think, Mr. President, that this bill, these provisions, these proposals are reasonable, proportionate, and necessary in all of the circumstances. And we say, Mr. President, 10 minutes, sorry, I'm not going to take long. I don't think we should have much of a palaver today, but we have stated our position with respect to the reasonableness and proportionality of this legislation, the fact that we deal with non-intimate samples. We say, Mr. President, that these amendments are in keeping with the manifesto of the government, which is committed to the prioritization of investment in forensic sciences for the purpose of ensuring timely sample analysis, inclusive of drug and firearm analysis, and the collection and storage of DNA profiles from persons who are foreign terrorist fighters or returnees as defined would represent a practical extension of this commitment. And in these circumstances, Mr. President, I propose that the Administration of Justice Deoxyribonucleic acid Amendment Bill 2026 be duly considered and accepted by this Honorable Senate. Mr. President, I beg to move.
Honorable Senators, I shall now pose the question for debate. The question is that a bill entitled an Act to amend the Administration of Justice, Deoxyribonucleic Acid Act, Chapter 534, be now read a second time. I recognize Senator Sanjiv Boodhu.
Thank you very much, Mr. President. A very pleasant good afternoon. Thank you for permitting me to enter the debate this afternoon. Mr. President, the bill before this Honorable Senate is deceptively short. It is 4 clauses, 3 pages, and a schedule. But sometimes, Mr. President, the shortest of bills carry the broadest implications for liberty, constitutionalism, citizenship, executive power, and the relationship between the state and the individual, Mr. President. And at its core, this bill seeks to amend the existing Administration of Justice DNA Act to expand the compulsory DNA sampling to two new categories of persons, one being foreign terrorist fighters and the other being returnees, Mr. President. And permit me to say from the outset that no responsible senator can ignore the genuine national security concerns which animate this legislation. Trinidad and Tobago has in fact lived through the reality of radicalization. We have seen citizens travel to conflict zones. We have heard the concerns of our international partners. We know the dangers posed by organized extremist networks. We understand the fear of innocent citizens who simply want to live safely. But equally, Mr. President, fear cannot become the architecture of governance. Because, Mr. President, the true test of democracy is not whether a country can exercise power. Every state can exercise power. The real test is whether a state can restrain power. And it is that restraint, that constitutional discipline, which this bill dangerously weakens. The explanatory note on Clause 4 tells us plainly that the objective is to strengthen national security and counter-terrorism efforts by aligning the DNA Act with the Anti-Terrorism Act. Now, that sounds reasonable on its first reading, but when one actually examines the clauses carefully, one discovers that this bill creates something far more troubling than a mere administrative amendment, Mr. President. It creates a framework whereby the executive may effectively designate an individual as a terrorism risk without judicial oversight, without conviction, without charge, without hearing, and in some cases without even disclosure of the evidential basis for that designation, Mr. President. And once so designated, that person may be compelled to provide DNA. In fact, that is the purpose of the bill, as a condition connected to entry or re-entry into Trinidad and Tobago. That is a profound constitutional development. Mr. President, let's examine the bill clause by clause. Clause 3 inserts a new definition of retainee. Part A of that clause concerns persons returning from declared geographical areas associated with terrorism and who were detained in camps or facilities there. One can at least understand the policy logic behind enhanced scrutiny in such circumstances. But paragraph B is where the constitutional alarm bells start ringing very loudly, Mr. President. It defines a returnee as a person, quote, who the minister with responsibility for the Anti-Terrorism Act has reasonable grounds to believe poses a threat or risk of committing a terrorist act and who is not a foreign terrorist fighter. Let's read that carefully, Mr. President. It's no court, it's no judicial warrant, it's no tribunal, it's no requirement that evidence be tested, it's no obligation to notify the person beforehand, there's no mechanism for challenge before the designation, there's no requirement for any independent review, there is no structure for an appeal, there's no requirement even that the person be charged with any offense whatsoever. The minister merely has to possess reasonable grounds to believe. And immediately, members opposite may raise the point that reasonable grounds is a recognized legal standard, and yes, it is. But in constitutional democracies, reasonable grounds generally become meaningful when they are tested by an independent adjudicator, Mr. President. It is not when it is left exclusively within the subjective discretion of a minister appointed by the Prime Minister of the day. And that distinction matters enormously in this context, Mr. President. Because you see, the bill is not merely authorizing the surveillance or a temporary detention at a port of entry. It is authorizing the compulsory extraction of biological identifiers from citizens and persons entering Trinidad and Tobago. DNA is intensely personal, as we can all accept, Mr. President. It contains familial information, hereditary markers, biological identity, and deeply private personal data. And the jurisprudence internationally recognizes that compulsory DNA collection engages constitutional rights relating to privacy, bodily integrity, liberty, and dignity. Now, the existing Administration of Justice DNA Act was originally crafted primarily around the criminal justice processes. It relates to convicted offenders, suspects under judicial process, forensic comparison, and evidentiary safeguards, Mr. President. But this bill moves the legislation away from criminal justice and into preventative executive designation. That's a significant paradigm shift. Mr. President, there is another issue that must be dealt with. Clause 4 of the bill, Mr. President, amends the section 16.1 of the parent legislation by adding persons who are returnees or persons deemed to be a foreign terrorist fighter. And again, here the wording is important, Mr. President. The word used is deemed, not convicted, not proven, not adjudicated, deemed. And deemed by whom? Ultimately by the minister with the relevant responsibility. And this creates an architecture whereby a minister, and that is any government minister controlling the ministry responsible for the Anti-Terrorism Act, can trigger what is described here to be invasive state powers over individuals without first satisfying any court. So for the benefit of the listening and viewing public who may be deemed to have to interact with this legislation when it is passed, let us examine the current state of the law and compare it to what this amendment is enacting, and enacting, very importantly, without a special majority, Mr. President. Now, I mentioned earlier that this bill introduces two new categories of persons who will have to give a DNA sample. That's because the existing legislation provides several categories of persons that must have a non-intimate sample taken from them without consent. These categories of persons, Mr. President, include a suspect, a detainee, an accused person, or a deported person. And it also includes members of the protective services and staff at the Forensic Sciences Center. And the latter categories, the arms of law enforcement, this is a means to exclude them from being a suspect in the course of a criminal investigation. The collection of their data is to explain why their DNA might be found on a crime scene without identifying the law enforcement personnel as a suspect in the offense, where there's a very common sense rationale as to why they are included. But the former categories, suspect, detainee, accused, and deportee, these categories of persons I wish to examine for the benefit of the listening public, Mr. President. The terms suspect, detainee, and accused are defined in the Principal Act in Section 4. A suspect is defined as a person whom the police have reasonable grounds for believing is about to commit an offense or may have committed an offense and who is being investigated by the police in relation to that offense. A detainee is someone who is lawfully held in custody. An accused means someone who is charged with an offense. A deportee is not defined in the Principal Act, but we know that a person is deported from another country generally because they have committed some crime, including some immigration offense. And the deporting country is saying to us in Trinidad, we don't want this person in our country because of what he or she has done contrary to the law. But there's a common thread in all of that, and that it is the police The definition of suspect refers specifically to someone so designated by the police, not by a minister. The same with a detainee. A detainee is someone lawfully held in custody, Mr. President. You can only be lawfully held in custody by the police or by some other law enforcement agency with precept powers of arrest. And it is the same with the accused. This is someone who has been charged by the police. And it is the same with a deportee. This is someone who has done something, some law enforcement agency or some prosecutorial office or some immigration department somewhere in the world must have concluded that you have done something contrary to the law. So the current state of the law is that it is the police that determines you must have a DNA sample taken from you without your consent, Mr. President. Now, how do the police arrive at this determination? Now, first of all, the police are all subject to the law, and they must confine themselves to the Police Service Act and the Police Service Standing Orders and the judge's rules and every other piece of legislation that is in place and every locus classicus or binding judicial decision that tells the police what qualifies as probable cause. What evidence, information, and observances must be made before it is lawful to determine someone is a suspect in the first place. And we accept, of course, that before you can be a detainee, a lawful detainee, before you can be an accused, you are first a suspect. And the police are trained in all of this, Mr. President. There are almost endless checks and balances on the exercise of lawful police discretion. And yet still, even in the face of all of those checks and balances and laws and regulations and standing orders and case law, the police still sometimes get it wrong. The police are still, after following all of this and acting independently as they are required to do, and acting unmotivated by any malice as they are required to act in law, they still sometimes make the wrong determination. Or they color, or, Mr. President, they deem the wrong person as a suspect. It happens all the time, Mr. President. Yet here we are in this bill saying that a minister can exercise this discretion in a manner that is lawful, that is independent, that is objective, absent of any bias and political motivation, and based upon evidence or intelligence, Mr. President. We are saying that a minister who does not necessarily have any policing training or experience, or does not necessarily have any legal training, specifically any criminal or prosecutorial training or experience. We are here passing a bill to empower that minister to designate someone a returnee under Clause 3B of the bill, or worse yet, we are empowering that minister to deem someone a foreign terrorist fighter under Clause 4 of the bill. Mr. President, these powers are simply and plainly excessive, unconstitutional, and they are downright dangerous, Mr. President. Now, Mr. President, I wish for a moment to look back at Clause 3 of the bill, which defines foreign terrorist fighter, and it attaches to it the meaning assigned under Section 15A of the Anti-Terrorism Act. Now, that Section 15A at subsection 1 says a person who knowingly and without lawful cause, without lawful excuse rather, travels for the purpose of A, planning a terrorist act, B, committing a terrorist act, C, supporting a terrorist act, D, facilitating the commission of a terrorist act, commits an offense and shall on conviction, on indictment, be liable to a fine of $25 million and to imprisonment for 25 years. That's what 15A says, subsection 1. 15A subsection 2 reads, a person who commits an offense under subsection 1 shall be deemed a foreign terrorist fighter. So it literally means that a person must have been charged with an offense under 15A1, tried in court, and convicted of that offense, and only then would they be deemed, pursuant to subsection 2, a foreign terrorist fighter, Mr. President. That is the only way that the deeming provision of Section 15A2 can apply. It's as if someone is found guilty, pleads guilty, or in either event is convicted of the offense. It is the only way. And that further means that not only would the person have to be investigated by the police and prosecuted by the office of the DPP, the person would have had to have been tried either before a judge alone or a judge and jury. There are therefore three colliding functionaries: the police, the DPP, and the judiciary, before anyone can be deemed, pursuant to the subsection 2, as a foreign terrorist fighter. All of that. But clause 4 of this bill, Mr. President, gives the minister that is appointed by the Prime Minister of the day, unfettered authority to deem someone a foreign terrorist fighter. So what about judicial oversight, Mr. President? Section 22B of the Anti-Terrorism Act is instructive in relation to judicial oversight as well. This section makes provision such that where the AG, the Attorney General, receives information that an individual committed or participated in a terrorist act or is acting on behalf of a designated entity that has knowingly committed or participated in the commission of a terrorist act, or has committed an indictable offense for the benefit of a terrorist, the Attorney General shall cause an investigation to be carried out and may refer the matter to the Commissioner of Police for an investigation to be carried out. And thereafter, the Attorney General shall apply to a judge for an order that declares the individual to be a terrorist. Now, even in pursuing that course of action, the Attorney General must file an application supported by affidavit evidence in order to invoke the jurisdiction of the court. And the person who is subject to the application, the person being accused of having committed any of these acts, shall be served with a copy of the order and may, within 60 days of either service or publication of the order, there are a number of requirements in terms of publicizing the order, apply to a judge for a review of the order within 60 days. Section 22B at subsection 3C goes a little further to anticipate a real-life problem or situation that can arise and does arise in criminal proceedings. And that subsection says that a person likely to be affected by an order, meaning generally speaking, the person who is subject to that application, may include a person with the same or similar name. What that section has taken into consideration, Mr. President, is that mistakes can naturally occur, and the law ought to be very cautious not to wrongfully or without due process and natural justice condemn any citizen to the permanent and deleterious effects of being wrongfully branded as a terrorist. And the section goes on for 12 subsections about how this process is to be managed by the court. So, Mr. President, how are we to feel comfortable putting all of those legislative and judicial safeguards aside and placing them in the hands of a minister, whoever that minister may be from time to time? And it is not about the current minister. I take no issue with the existing minister with the responsibility for this. There's not a personality thing here, but Mr. President, in our system of parliamentary democracy, if a prime minister wishes to appoint a new minister this afternoon, tomorrow morning, next week, the prime minister can do so. A minister serves at the pleasure of the prime minister. But that is not so for a judge, Mr. President. One cannot appoint or remove or censure or censor or illicitly persuade a judge of the High Court by any political inducements, threats, or otherwise, and that is, again, not to cast aspersion on any minister. This is a general observation, because, Mr. President, we are in dangerous territory with this amendment, and the public ought rightly to be concerned about this. And, Mr. President, we in the opposition will always discharge our obligations to inform and educate the people of Trinidad and Tobago. Now, my learned friend, the leader of government business, argued that the deeming authority in clause 4 of the bill is only effective or applicable insofar as this particular bill goes. Specifically, that the minister could only deem somebody a foreign terrorist fighter for the purposes of obtaining a DNA sample without consent. The minister's deeming authority does not extend into the indictable offenses created by the Anti-Terrorism Act, and that argument is true on the face and on the surface of the argument, Mr. President. But it is nuanced and that argument is also incomplete. That argument is not a contextual argument and would not be considerate of all of these circumstances, Mr. President. Because, Mr. President, ask yourself the question, will anyone, will you, will I, will members of the public take any comfort in knowing that you have been designated as a foreign terrorist fighter, but it is only for the purposes of extracting your DNA? It is not in pursuit of any prosecution. Will that make anybody feel any better? Does it concern anyone any less? Should it concern anyone any less? The literal and legislative effect of being deemed a foreign terrorist fighter pursuant to this bill might be the DNA sample, but the actual real-life effect of being deemed a foreign terrorist fighter is far more serious. Mr. President, in a society as small as ours, where news travels faster than light, who will take any comfort in that literal interpretation? And the question must be asked, are we as legislators comfortable in ignoring the cultural orientation of our society when we draft laws? I certainly am not. We draft laws not only to be legally functional, not only to have a strict legislative effect. We draft laws to govern our society and that society as it is, Mr. President. We draft laws to benefit the people of our country, and it requires us necessarily to understand the nuances of our people, our society, and our culture. We are required to be sensitive to these realities. We are required to be aware of the serious and permanent reputational injury that can result from a minister's exercise of this deeming provision. It is not sufficient to say that we are not prosecuting the person as a terrorist. And even if you wish to mount that argument, then the question arises, if you're not necessarily chasing a prosecution, why deem someone a foreign terrorist fighter with that term, with that definition, Mr. President, for the sole purpose of obtaining a DNA sample at all? To mount that argument is to make an admission that there is a possibility that people will be deemed a foreign terrorist fighter without sufficient evidence upon which any successful prosecution can be achieved. And that scenario brings us to the fundamental question, Mr. President, which Senator Vieira always asks. What exactly are we attempting to achieve? Is it that we are attempting to achieve a mass database of DNA, or is it that we are operating on reliable and credible intelligence, exchange of information between territories, and evidence with the intention to prosecute those who have broken the law? All in all, mixing executive power with the power to socially condemn a person for life by a designation of this nature is a dangerous concoction that is reasonably foreseeable to result in executive abuse, political abuse, and litigation against the state, further costing the taxpayer, in addition to a further deterioration of the trust and confidence that ought to exist between the people and the state, and more relevant to daily life, the trust and confidence that ought to exist between the people and law enforcement. We are dealing here with the intersection of national security, constitutional rights, citizenship, morality, international law, and human tragedy, Mr. President. And therefore, the law we create must be careful, restrained, and intelligent. Mr. President, there is also a constitutional question concerning the right of entry into one's own country. A citizen's right to enter Trinidad and Tobago is not a gift from the executive. It is a foundational constitutional principle tied to citizenship itself. And what this bill effectively does is create conditions under which a citizen may only fully re-enter after compulsory submission to state extraction of DNA under executive designation mechanisms. That deserves serious scrutiny, because while the state may regulate entry procedures for national security purposes, such measures must still satisfy constitutional tests of proportionality, legality, and procedural fairness. So my questions are, where is the judicial safeguard? Where is the independent review? Where is the right and access to appeal? Where is the mechanism to challenge wrongful designation? Where is the destruction protocol if the suspicion proves unfounded? Where are the limits on retention? Where are the protections against secondary use? Where are the parliamentary reporting requirements? And where are the safeguards against politicization? And the answer is, Mr. President, they are all absent. This bill allows the executive, the minister, to become the investigator, the assessor, and the trigger mechanism simultaneously. That concentration of power should concern every senator in this chamber, opposition, independent, and government. And if they are truly interested in fair, transparent, and justiciable legislation that produces balanced safety for all of our citizens in a manner that can fortify public trust and confidence in our public systems, Mr. President, constitutional and judicial protections cannot be treated as partisan instruments. They protect everybody. And they protect even the members opposite when they return to this side in the not too distant future. Now, Mr. President, I wish to address practicality. Suppose a person is wrongly designated, or suppose the intelligence upon which the minister makes a decision is flawed. Suppose, as the Section 22A2 contemplates, identity is mistaken. Suppose a person has traveled through a region unaware that it is either designated or on some radar of the Attorney General or the relevant minister. Suppose somebody is forcibly taken as a minor and wishes to return as an adult, or a child born in a camp is now 10 years old and wishes to return. What about a humanitarian worker who is misidentified in all of this? What remedy exists under this bill before the DNA extraction occurs? Or more concerningly, the designation occurs. I'm more concerned about the designation. What remedy exists before? What remedy exists after? The answer is none, and that is dangerous. I accept wholeheartedly that the state must have the power to protect the public, but, Mr. President, that power must operate within transparent constitutional guardrails. And while national security is real, it cannot become a magic phrase that dissolves constitutionality. Around the world, democratic states confronting terrorism have struggled with this exact balance, Mr. President. The UK, Canada, Australia, and jurisdictions in the European area have repeatedly had anti-terror provisions challenged before the courts on grounds of proportionality, arbitrariness, and excessive executive discretion. And the lessons emerging globally are all clear, and it is that security measures survive constitutional scrutiny when accompanied by robust safeguards. It is not when it is based primarily on trust in ministerial restraint, because constitutional law assumes something important, Mr. President. Power must not depend on personalities. It must depend on systems, Mr. President. And permit me to be clear, lest my contribution this afternoon be mischaracterized, which I suspect it might. I am not advocating for recklessness. I am not suggesting that the state should ignore potential terrorism threats. I'm not saying that intelligence agencies should be powerless, but I believe, in fact, that DNA collection may, in certain tightly regulated circumstances, serve legitimate national security purposes. And it does in the current framework, as we have discussed earlier. But if the government wishes to exercise extraordinary powers, then extraordinary safeguards must accompany that. That is the balance that mature democracies pursue, Mr. President. And therefore, rather than opposing merely for the sake of opposition, let me offer some constructive proposals, as I like to do. The designation process should require judicial confirmation within a fixed period. And this judicial confirmation or safeguard can be mirrored to meet the established procedures of the existing Section 22B of the Anti-Terrorism Act. If a minister believes that there are reasonable grounds, then place the evidence before a judge. And there is no need for any protracted proceedings. A notice of application supported by an affidavit with its evidence attached, including any information received from our reliable international counterparts and relevant law enforcement agencies, would suffice and permit the person attempting to return to provide an explanation or justification. Let an independent judicial officer, specifically a high court judge, determine whether the threshold is met and permit the subject of that order the person, the opportunity to challenge and present their case as appropriate. Due process in all things is important, and it is essential. Second, consider introducing an emergency temporary power where immediate action is necessary at ports of entry, but subject to a rapid and proximate judicial assessment thereafter. Third, the legislation should create a statutory right of challenge and review for affected individuals. Fourth, Parliament should receive periodic anonymized oversight reports regarding the use of these powers and any discretion exercised by a member of the executive, whether it is a minister with responsibility or the Attorney General, as the case might be. Fifth, special provisions should exist for minors, trafficked persons, and vulnerable individuals. Sixth, if the government insists on holding on to some ministerial discretion, make that discretion available in limited circumstances of perhaps the most urgent of cases, and substantially narrow those discretionary powers to avoid vague and potentially expansive or inconsistent and arbitrary exercises of executive discretion. Give the minister some evidentiary tests, standards, and requirements, and make it something transparent and certain so that all of the parties involved can operate on an even playing field, and so that those interacting with this system can have faith and confidence that the process is fair, that it is transparent, that it is just, that it does not create the opportunity for either personal victimization or personal favoritism. Overarchingly, Mr. President, if the government truly believes in the legitimacy of these powers that are contemplated in this bill, then the government should not fear judicial oversight, because it is that judicial oversight that strengthens legitimacy. It doesn't weaken security. When citizens trust the fairness of institutions, cooperation with law enforcement improves. But when powers appear arbitrary, public confidence deteriorates, and public trust itself is a national security asset. Do we believe that ministers should possess broad unilateral designation powers over citizens, or do we believe liberty requires institutional safeguards? And I wrap up by saying this, Mr. President. Every nation has moments where fear tempts it toward overreach. History is filled with examples. The nations remembered honorably are not the ones that never faced danger. They are the ones that confronted danger without abandoning principle. This Senate must therefore legislate with wisdom, restraint, and foresight. Protect the nation, yes, by all means, but protect also the Constitution, protect the citizen, protect due process, protect the principle that in Trinidad and Tobago, no person should be subjective to invasive state power solely on the unchecked discretion of the executive. That balance is not weakness, Mr. President. That balance is democracy itself. I thank you very kindly, Mr. President.
Senator Dr. Desirée Murray.
Mr. President, I rise to contribute to the debate on the administration of Justice DNA Amendment Bill 2026. Let me say straight off the bat that I support this bill. Foreign terrorist fighters and returnees, as defined under the provisions of this legislation, may return to our shores harboring deeply entrenched radical ideologies. That possibility must be treated with the seriousness it demands. However, these individuals are bona fide Trinidad and Tobago citizens and are entitled to the full support of the state as they seek to reintegrate into society. Every effort must be made to facilitate meaningful rehabilitation. That does not mean that we should deny or ignore the sobering reality that some of these individuals pose a potential national security threat. Accordingly, it is imperative that robust monitoring mechanisms be maintained alongside any rehabilitative or de-radicalization efforts where warranted. Where an individual commits a criminal offense, they should bear the full brunt of the law. Systems should be in place to identify and prosecute them. On that basis, I have no objection to the purpose and the spirit of this legislation. However, I am also of the view that this bill is inconsistent with Section 4B, C, and D of the Constitution, which enshrines without discrimination by reason of race, origin, color, religion, or sex, the right of the individual to equality before the law and the protection of the law, the right of the individual to respect for his private and family life, and the right of the individual to equality of treatment from any public authority in the exercise of any functions. The power to take a non-intimate sample without consent is a significant incursion on bodily autonomy and personal privacy. This is especially concerning given the fact that some of these returnees are likely to be children, and some may even be unaccompanied minors, who may have been affected by exposure to radical ideations in conflict zones. The leader of government business used the word may in this context, so they are not automatically considered to have been radicalized. Constitutional rights are in fact being breached, and that should be acknowledged by seeking the support of 3/5 of all members of the Senate for passage of the bill. That may preempt challenges in court, which could in fact delay the protection that the Act seeks to afford to citizens. Mr. President, my contribution to this debate is delivered in a spirit of constructive engagement, because the Parent Act touches on matters that are fundamental to the integrity of our criminal justice system, the protection of the innocent, and the advancement of clinical medicine and public health in Trinidad and Tobago. DNA evidence, when properly collected, processed, and presented, can convict the guilty and exonerate the innocent. DNA can also be useful in the diagnosis and management of hereditary diseases. However, the science is only as reliable as the institution that administers it. And it is on that point that I must today raise serious and urgent concerns about the fact that the Trinidad and Tobago Forensic Science Center is not an accredited body. I will speak more on that fact a bit later in my contribution. But before addressing the institutional concerns that must accompany this bill, let me engage directly with the substantive provisions as detailed in clauses 3 and 4. Clause 3 defines foreign terrorist fighter and returnee. These definitions are a direct legislative response to the well-documented phenomenon of Trinidad and Tobago's nationals who traveled to conflict zones, mostly notably the territories once controlled by the Islamic State in Iraq and Syria, and who are now seeking to return home, or whose relatives are now seeking to return. Trinidad and Tobago has the unfortunate distinction of having produced per capita among the highest numbers of foreign terrorist fighters in the Western Hemisphere. So radicalization is not the exclusive dominion of these so-called declared geographical areas, and may in fact be homegrown. Trinidad and Tobago, the return of these individuals and the spouses and children of those who did not survive and who may have been involuntary participants in the circumstances that led to their detention presents one of the most serious and complex national security challenges that we face. Accurate identification of returnees and foreign terrorist fighters through DNA analysis serves a legitimate and pressing national security purpose. DNA can establish biological relationships, critical for identifying unaccompanied minors, resolving contested identities, and linking individuals to others already in criminal databases. Clause 4 amends Section 16 of the Act. Currently, the Act provides for non-intimate samples of deported citizens to be taken without their consent upon their return. Clause 4 extends that power to persons deemed to be returnees or foreign terrorist fighters as now defined by Clause 3. It is precisely here that the institutional deficiencies become most acute. A non-intimate sample taken from a foreign terrorist fighter or a returnee at an airport or seaport and processed through an unaccredited laboratory, stored in conditions of questionable integrity, and analyzed by an understaffed unit is a legal liability, not an asset, as its evidential value will be immediately vulnerable to challenge. Let me place on record why accreditation matters. Forensic DNA laboratories serve distinct purposes and must meet recognized standards to ensure that their methods are scientifically valid. Their chain of custody is unbroken, and their results can withstand rigorous cross-examination in a court of law. Non-accredited facilities are, by definition, not subject to that level of external scrutiny. Errors may go undetected. Contamination may go unacknowledged. And if that material finds its way into a court as evidence, the entire case built upon it becomes vulnerable to collapse. Not because the science was wrong, but because the institution handling it could not demonstrate the standard required. Mr. President, the Parent Act, Part Roman numeral 2, Forensic DNA Laboratories, states that the Trinidad and Tobago Forensic Science Center shall be the official forensic DNA laboratory for Trinidad and Tobago. Yet, in moving the bill in the other place, the Minister of Defense indicated that the government is, and I quote, urgently working with an international accrediting agency to have the accreditation of the Forensic Science Center seen to completion, unquote. Mr. President, I have the benefit of the contribution of the Minister of Defense during the debate on the Victims' Rights Bill in this House, and I intend to draw from it directly because the Minister's own words make the case for the concerns I have raised more powerfully than I could make them myself. Perhaps the most illuminating passage in the Minister's contribution came while he was speaking based on his experience as a criminal defense attorney. The Minister said, and I quote his exact words, "We have a very low conviction rate, and we have a low conviction rate not because of victims. Criminal defense attorneys would tell you that the easiest way to win a case is basically show up the incompetence of the police and to show that their incompetence basically had an adverse impact on the fairness of the proceedings and cast doubt upon the guilt of a man who might actually be guilty." Unquote. Mr. President, this bill proposes expansion of the power to take DNA samples without consent from persons arriving at our ports of entry. And yet, the government has acknowledged that the low conviction rate in this country is not primarily a problem of the law books. It is a problem of institutional integrity. The integrity of the investigation, the integrity of the evidence collection, the integrity of the scientific analysis, and ultimately, the credibility of the case the prosecution presents to court. The Honorable Minister of Defense is no ordinary advocate for this legislation. He's a seasoned criminal defense lawyer with over 26 years of courtroom experience. So he knows better than most what happens when forensic evidence is challenged at trial. He knows what it means to sit on the defense side of the bar and look for the weaknesses in a prosecution's scientific case. The lesson for DNA evidence is exact and inescapable. The question a jury will ask is not simply whether a DNA profile matches. The question will be, can we trust the institution that produced it? Can we trust the chain of custody? Can we trust the laboratory? Can we trust the science? And if the answer to any of those questions is no, if defense counsel can demonstrate that the laboratory that produced the DNA evidence is not accredited to international standards, that its equipment has previously failed, that its physical conditions have been described in official reports as inadequate, then the jury, applying the very logic the minister himself articulated, will acquit. The minister's own words make the case for my concerns more powerfully than I could make them myself. Now, I know the minister has confirmed that advertisements have been placed for vacant positions in the custodian unit, including deputy custodian manager, data bank analyst, and business operations assistant 2, and that the Ministry of Justice is in the process of preparing a shortlist. But this is in itself acknowledgement of institutional deficit. Mr. President, this is a matter of particular significance in the context of this debate. There's a central tension that this bill must confront. We are expanding the categories of persons from whom DNA samples are taken to establish DNA profiles, while the institutional framework for processing, storing, and using those profiles has not yet achieved the international accreditation on which their evidential and intelligence value depends. Mr. President, accreditation must be obtained before the expanded powers of this bill are relied upon in any serious prosecution. Every DNA sample that passes through an unaccredited laboratory is a case waiting to be overturned. Mr. President, it's worth pausing to consider what DNA evidence has actually achieved in the courts of Trinidad and Tobago, and perhaps more strikingly, what it has not achieved. The most documented contribution of DNA to our justice system has not been the conviction of the guilty, but the exoneration of the innocent. The first recorded use of DNA to free an accused person in this country occurred when a man who had spent years in prison, having been identified by 2 women at police identification, was charged with rape and grievous sexual assault. He was set free after DNA testing at the forensic science excluded him as the source of biological material recovered from the complainants. So, Mr. President, when we turn to the question of convictions, however, which rests squarely on DNA evidence, the picture is notably sparse. There are precious few conviction cases, if any, in which a conviction in a Trinidad and Tobago court has turned principally on DNA analysis produced by the Forensic Science Center. And the reasons for this are directly connected to the institutional deficiencies I've already described. So among the most significant issues aired before court was the fact that the Forensic Science Center did not have a national statistical database and was not accredited. DNA evidence in Trinidad and Tobago has proven its worth as a tool of exoneration, but not of conviction. So expanding the categories of persons sampled without addressing deficiencies in how these samples are processed simply means collecting more evidence that may ultimately prove unusable. There's one further consequence of the accreditation deficit that I want to place on record. Terrorism is by its nature transnational. the foreign terrorist fighters and returnees at whom clauses 3 and 4 are directed did not operate in isolation. They are connected to networks, financing, recruitment, and logistical networks spanning multiple jurisdictions. But the intelligence value of DNA profiles taken from returning fighters lies not only in those profiles domestically, but in their potential to be shared with international partners who are tracking the same networks. The FBI's CODIS system, the Combined DNA Index System, which is the world's largest forensic DNA database, requires that contributing laboratories be accredited and meet specific FBI quality assurance standards. These are not bureaucratic niceties. They are safeguards designed to ensure that profiles shared across borders can be relied upon in foreign courts and intelligence assessments. A DNA profile produced by the Forensic Science Center in Trinidad and Tobago in its current unaccredited state may simply not be accepted into those systems. We will have exercised an intrusive power, taken a non-consensual sample from a person on arrival, and produced evidence that is inadmissible at home and suspect abroad. So this is a security liability, and it is a direct and foreseeable consequence of expanding the sampling powers of the Act before the institutional foundation on which those powers rest has been properly secured. Mr. DNA, oh my goodness, I beg your pardon. Mr. President, Mr. President, DNA analysis has applications far beyond the forensic laboratory. And I want to make a shameless plug for clinical medicine and public health, if you would please indulge me. Investment in DNA expertise at the Forensic Science Center is not only a criminal justice matter. It is a matter of national development. In clinical medicine, DNA testing can identify genetic mutations associated with hereditary diseases, and it can guide personalized treatment, enabling early intervention in conditions that, if caught late, may cause devastation and be very costly. So in the Caribbean context, where certain genetic conditions, including sickle cell disease and hereditary cancers, carry significant public health burdens, access to high-quality DNA diagnostic services is not a luxury. Although a standard forensic science center cannot process DNA samples for medical diagnostics, the lesson is this: if Trinidad and Tobago wishes to develop a genuine DNA science capacity, one that serves both the justice system and the healthcare system, we must invest in two streams of expertise with appropriate accreditation for each. They are complementary investments, and in my respectful view, they must be planned together. Local services are not available, particularly for paternity testing, which is apparently in very high demand, and that would spare citizens the cost of sending samples overseas at a cost of US $300 per test, which the citizens must pay in foreign exchange. So, Mr. President, in concluding, I wish to place on the record the specific questions that I believe this amendment bill must address, and which I respectfully request the Minister to answer before this legislation proceeds. First, given that the Trinidad and Tobago Forensic Science Center currently is not an approved forensic DNA laboratory under the 2012 Act, what is the legal basis on which DNA evidence from that center is being admitted in criminal proceedings? Second, what are the plans and timelines for obtaining international accreditation? Third, what is the staffing establishment required for a fully functional accredited DNA laboratory, And what is the current shortfall in terms of vacancies, expertise, and remuneration? Fourth, what arrangements are in place to ensure that the new Forensic Science Center at Farm Road, which the government of the Republic of China dedicated funding for, will happen? Is this something that is still on the cards? Fifth, has the government conducted a legal risk assessment for the potential for DNA evidence to be successfully challenged in court on the grounds that the center lacks accreditation? Six, what protocols are in place or being developed to enable the lawful sharing of DNA profiles taken from returnees and foreign terrorist fighters under Clause 4 with international partners? Does the current state of the center's accreditation permit such sharing to proceed on terms acceptable to those partners? Seventh, what is the process for assessing whether foreign terrorist fighters and returnees have been radicalized, and what systems are in place to attempt de-radicalization if warranted? 8, and speaking from the perspective of an employer, given that these individuals will not have criminal records in this jurisdiction upon arrival in Trinidad and Tobago, what exactly will appear on their police certificate of character? Would police certificates of character indicate that these individuals are deemed to be foreign terrorist fighters or returnees? And what about criminal records in other jurisdictions? How will that be documented? So, is there going to be an updated or revised policy attached to the police certificates of character with respect to foreign terrorist fighters, returnees, refugees, or deportees? Mr. President, the Administration of Justice Deoxyribonucleic Acid Amendment Bill 2026 deals with a matter of profound importance to the people of this republic. DNA, when used well, is a tool of truth. It can deliver justice to victims of violent crime and protect the innocent from wrongful conviction. But it can only do so if the institution that handles it is credible, accredited, properly resourced, and legally sound. Trinidad and Tobago deserves a forensic science center of which we can be proud. We should avoid passing legislation that ignores the institutional foundations on which it rests. Mr. President, I thank you for allowing me the privilege of contributing to this debate.
Is there anyone else from the independent bench who would like to speak? Or the opposition? Before I call on the minister, the why not? Is there anybody else?
Am I required in a debate? Usually the government goes next.
No, the minister, I don't think they have speakers again.
Oh, sure.
So, the Honorable...
Under that
Faris.
assurance, Mr. President, I'm happy. Mr. President, thank you so much for allowing me the opportunity to join in this debate. Mr. President, I don't propose to be too long in submissions. I propose to be as targeted as I can. We have a bill before us which proposes, as Senator Allahar very capably crystallized, 3 categories of persons to be the subject of the provision of DNA samples. It's an amendment to the Administration of Justice DNA legislation, parent law. It is including specifically a foreign terrorist fighter as defined under Section 15A of the Anti-Terrorism Act, and a returnee, which is a new concept to our law, a new defined concept to our law, being a person who is entering Trinidad and Tobago from a declared geographical area where terrorist acts have occurred or are occurring, and who was detained in a facility, camp, or place of detention in that geographical area. The House amended the definition of returnee, and it has come to us to mean a person, and I'll read it as it came from the House, who is entering Trinidad and Tobago, A, from a declared geographical area, within the meaning assigned to it under Section 2.1 of the Anti-Terrorism Act, where terrorist acts have occurred or are occurring, and who was detained in a facility, camp, or place of detention in a declared geographical area. And this is the material amendment which brought us into serious consideration. B, who the minister with responsibility for the Anti-Terrorism Act, who has reasonable grounds to believe possesses a threat or risk of committing a terrorist act and who is not a foreign terrorist fighter. Now, I'd like to commend Senator Sanjiv Boodhu's discourse. It was a brilliant contribution, Mr. President, if I may say so myself. I don't propose to traverse the matters which he has spoken to. I propose to add to those matters insofar as I'm dealing with the relevance of this bill. Mr. President, I had cause as Attorney General to amend this law in 2018 by Act number 13 of 2018, by Act number 20 of 2018, by Act number 7 of 2019, by Act number 25 of 2020, by Act number 15 of 2024. And by this law, I mean the Anti-Terrorism Act. This Deoxyribonucleic legislation that we're treating with DNA Act, this law articulates by way of the sections that we are introducing now with the DNA legislation. Very importantly, it articulates with the Mutual Assistance in Criminal Matters Act as well. And that is a point that I will come to in a short while. When we're looking at the concept of capturing DNA, the House amendment holding on to this part B, a returnee means B, a person who the minister with responsibility for the Anti-Terrorism Act has reasonable grounds to believe possesses a threat or risk of committing a terrorist act and who is not a foreign terrorist fighter. There are two creatures in the Anti-Terrorism Act that have responsibility. One is the Honorable Attorney General, insofar as listings of terrorist entities that finance terrorism are concerned. That is under the provisions of Section 22A, beginning there. Or B, it is now the Minister of Defense, previously the Minister of National Security, held that portfolio. But this concept of returnee is most important. You see Senator Murray reflected upon it, and Senator Boodhu reflected upon it. The concept of returnee identifies the bifurcation of how you treat with terrorism from a legal perspective as a state. On the one hand, you criminalize terrorism in accordance with the United Nations conventions that require us to do that. And the conventions are set out in the Anti-Terrorism Act, Mr. President. There are several conventions that are defined to operate in this. Those conventions are the Tokyo Convention, 14 September 1963, the Hague Convention, 16 December 1970, the Civil Aviation at Montreal Convention, 23rd of September 1971, the Prevention of Crimes Against Internationally Protected Persons, etc., 14 December 1973, the Convention of 17 December 1979, the Convention on Nuclear Material, Vienna, 3rd March 1980, the Convention on Violence at Airports, Montreal, 24th February 1988, the Rome Convention of 10th March 1988, the Rome Convention, again, a different protocol, Suppression of Unlawful Acts, again, 10th March 1988, that of Montreal, 1st March 1991, 15th December 1997, and lastly, the United Nations Convention, 9th December 1999. I've listed those conventions because, Mr. President, to get mutual assistance under the trigger of this referral legislation, Senator Allahar used a very interesting concept in piloting the bill to say this is an administrative referral via the DNA Act to the Anti-Terrorism Act. And Senator Allahar posited that we should not be concerned about the effect, because this law, the DNA Act, in taking without consent your non-intimate sample, for instance, by a buccal swab or by a sample of hair, that you're not going to be treated as a foreign terrorist fighter. But, Mr. President, that is respectfully, in my view, not correct. It is not correct because there will be a record under the DNA legislation. Your biological sample will be stored. It will be stored for a period of time, and it may or may not be disposed of by application to the Commissioner of Police. Your DNA profile will be admitted to the bank. The immigration authorities will have a record of you being a person from whom samples were taken, and the administrative reference is to the Anti-Terrorism Act. Now, why I was completely surprised by Senator Allahar's submission that Suraj and Surat takes care of constitutionality because there's a legitimate aim, we're being proportionate, and it doesn't go as far as it needs to go. It's because, Mr. President, in 2018, by Act number 13 of 2018, Act number 20 of 2018, Act number 7 of 2019, Act number 25 of 2020, Act number 15 of 2024, 5 times in a row, the leader of the opposition, then now Prime Minister, and lead senator, at one point Senator Saddam Hussein, then became Representative Saddam Hussein, the Honorable Minister today, all insisted that we had to have a joint select committee of the Parliament convened for us to ensure that a 3/5 majority legislation approach was used. Mr. President, when I piloted the law and chaired the Joint Select Committee on Anti-Terrorism Reforms, I agreed with the approach of a special majority because the area, in particular to the Islamic community of Trinidad and Tobago, was so severe and serious. Now, Mr. President, terrorism is not confined to the Middle East. Indeed, the Honorable Attorney General has, this year alone, in civil proceedings under Section 22B of the Anti-Terrorism Act, in fact declared Tren de Aragua, a South American entity, as a terrorist entity. La FARC in Colombia has been declared by other states as a terrorist entity. It's not exclusively confined to the religious connection to Islam. Hezbollah, an entity that we all know, Hizbat Allah in Arabic means the party of God, literally is what it means. Hezbollah has been declared, Hamas has been declared, entities in Iran have been declared, ISIL has been declared, Al-Qaeda has been declared, meaning the base in Arabic, Al-Daesh has been declared, which is the ISIL Republic. We have had, under my hand as Attorney General, hundreds of listings in our courts. Why? Because to treat with the scourge of terrorism, today the knock on the door is for DNA. Today the knock on the door is for DNA, but yesterday the knock on the door was Trinidad and Tobago does not know judicially who or what a terrorist is until our courts become involved. And we as a government pursued listing of terrorist entities by the hundreds under UNSCR resolutions 1276 and 1373. Those are the UN Security Council resolutions that require you to take steps to name terrorists. We participated with the United States of America in listing some of our own citizens as terrorists. But, Mr. President, when these debates on anti-terrorism came up, then opposition, now government, was adamant that we in this country take account of the reality.
Mr. President, I rise on Standing Order 46-1. The member is carrying the debate all over, far from the original intent of this debate as far as I'm concerned. I just would like to point that out.
No, I'm listening to the member, and I'll stop him if it's necessary. Continue, please.
Mr. President, in today asking for DNA for a foreign terrorist fighter, I'm treating with the connection. I thank Senator Murray for raising Trinidad and Tobago's context, and I thank Senator Allahar in particular, who spent the first 40 minutes of his presentation dealing with this very issue on the United Nations conventions, Mr. President. And as they apply today in the conventions of who a foreign terrorist fighter is, because it's listed in the Anti-Terrorism Act, I'm saying in Trinidad and Tobago, a large portion of our citizens give financial contribution by way of zakat, by way of charitable donation, to entities that are unfortunately from time to time listed as terrorist entities, not by us but by other states. And therefore our citizens become the subject of red flag and blue flag notices as being associated with terrorism. And the purpose of this law, Senator Allahar having introduced this administrative linkage by the DNA Act to the Anti-Terrorism Act, the real jeopardy, apart from those which I associate myself with, led by Senator Sanjiv Boodhu, is that we are going to have people on record under this law, on record under the Immigration Act, on record under the DNA Act, which we're amending today, as persons who tick the box of having been detained and giving involuntary samples of their DNA under the rubric of either being a foreign terrorist fighter or being a person who the minister has designated as a person of such a characterization to be a cause for the concern of the citizens of this republic or a foreign jurisdiction as being involved in places where terrorism existed. Now, why is that relevant? Is that far-fetched? Mr. President, when you go to the definition of terrorism, and you go beyond Section 15A, which Senator Allahar referred to, Section 15A is followed by Section 15B. Section 15B is where you have the designation of a declared geographical area. I recall that debate very, very well, you know. Up and down the concerns as to why we could not have declared geographical areas. The UNC opposition opposed it to the core, Mr. President. To the core, they opposed it. This was at a time when people were leaving Trinidad and Tobago by the droves to go and participate in foreign terrorist fighting allegations. But if you look to the definition section of the Anti-Terrorism Act, and then you go to the Section 3 of the offenses for terrorism, Mr. President, you will see that the financing of terrorism is treated as anything that can support terrorist activities. When you go to a declared geographical area under Section 15B of this Act, which is preceded by Section 15A, here's what 15A says. A person who knowingly and without lawful excuse travels for purposes of planning a terrorist act, committing a terrorist act, supporting a terrorist act, facilitating the commission of a terrorist act, commits an offense. Mr. President, we had to amend this law to include, before you designate an area as a declared geographical area, that the leader of the opposition must be involved in that. That's in 15B. 15B2, the minister shall, prior to making a designation under 1, inform the leader of the opposition. So stringent was the concern that people could be caught into this net. But this law, as Senator Boodhu put it, was well protected by way of judicial intervention. Today we have come to say, hey, let's just call somebody a returnee. Let's call them a returnee. So where does this concept of returnee come from? Mr. President, the concept of returnee is actually quite well known in the United Kingdom, in Europe, in South Africa, in other places in the Commonwealth, Mr. President. But it's well known to us, and the Office of the Attorney General would know it, Mr. President, because, in fact, there's a returnees bill that was drafted. I drafted the returnees bill. The returnees bill 2022 dealt with the creation of a concept of a returnee, and a returnee was specifically going to be somebody who was coming from a declared geographical area, as we do now. But, Mr. President, that person wasn't just by the minister's say-so going to be a returnee, which this bill proffers. that person was going to be under a judicial temporary exclusion order. You had to go to court, you had to produce an affidavit, you had to say that these people were coming in, and that is when you became a returnee, Mr. President, not by the minister's say-so alone. Now, I know we're going immediately to a wrap-up with Senator Allahar, so I'm sure that he will speak with that because he has said through you, Mr. President, that there are no more government speakers. Sorry?
Under 113 of our standing orders, agreement between the benches, once I'm informed, I will effect. Any member can come before me, Senator Darrell Allahar, leader, Senator Brown, or Senator Choud. At the end of the day, who catches my eye will rise. I am under no obligation from any leader of any bench to take their views. I'm guided by the standing orders. So if you go to 42, subsection 3, it tells you you have to catch my eyes. So I don't want you to be that presumptuous. I did say what I said, but at the end of the day, I am clarifying for this entire Senate, including your good self. Unless there is an agreement, catch my eyes. Continue.
Thank you, Mr. President. I'm guided by your direct words. I thank you for your clarification because I did ask specifically and you did answer. So I know that you said what you said, Mr. President, and I'm grateful for it. I was told specifically there's nobody else. There's one to wrap up. I'm guided, Mr. President.
Take your seat. Take your seat. You have a tendency to query the chair. I am not prepared to allow that. When I roll, you move on. If you cannot move on, let me know, take your seat. I'll go to the next speaker. But don't challenge your chair. This is a warning. Continue.
Thank you for your ruling, Mr. President. Thank you for your ruling, Mr. President. We're on DNA. DNA is a powerful tool, Mr. President. The submission that I'm making is that the administrative linkage that Senator Allahar put onto the table in saying that there's no prejudice to you by being recorded as a person, Mr. President, there is in fact a prejudice. I am saying that the concept of returnee has come from legislation, draft legislation that I drafted coming from other places. And I'm saying, Mr. President, that the returnee, when lifted from that bill that I drafted, came from an ethos and a structure which provided for judicial declaration as to when you're a returnee. This bill, Mr. President, has absolutely none of those safeguards. And without those safeguards, Mr. President, without those safeguards, you are going to be labeled as a person giving DNA for the purposes of being a returnee. And as a returnee, you would have the Minister of Defense alone saying that he considers it without judicial involvement until later in the day when you're challenging by way of judicial review, according to Senator Allahar. It is the Minister of Defense alone who is going to be saying, you are a person he considers as a risk for Trinidad and Tobago, Mr. President. Mr. President, my submission is that that is entirely improper. It is improper to the many people in Trinidad and Tobago who will find themselves in that net, Mr. President. And therefore, it is also improper because it goes against the direct submissions of the then opposition, now government, when they were in opposition, Mr. President. Mr. President, I can tell you for a fact, and I'm not asking, that there are Trinidad and Tobago citizens and their descendants who are imprisoned previously and now based at Al-Rawi camp in northeastern Syria. I can tell you for a fact that of the more than 5,049 ISIS members that were imprisoned there, 130 persons from Trinidad and Tobago are involved. I can tell you for a fact that those 130 persons are in current discussions with the Republic of Iraq to seek repatriation to Trinidad and Tobago. I'm telling you that as a matter of fact from international sources. Mr. President, this might seem like just simple little DNA and let me take a little buccal swab, Mr. President. That's not what this is, you know. This has been acknowledged by the Honorable Attorney General Israel. The Honorable Attorney General, under his hand, 5th day of March 2026, triggered an order under the Mutual Assistance in Criminal Matters Act, Chapter 1124, where he declared under Section 33 of that law that the Transnational Organized Crime Treaty is to be treated as a Mutual Assistance in Criminal Matters Act treaty for the state of the United Arab Emirates, for the Republic of Iraq, for the Kingdom of Belgium. That is directly associated, in my view, until the Honorable Attorney General says otherwise, to the repatriation of at least 130 persons, Mr. President. That says that there's a legitimate aim in the repatriation of persons. But this bill, which was a consequential amendment to the DNA Act in the law that I drafted in 2022, does not protect us, Mr. President, from the risk and harm that can come from violent extremism that is involved in the mindset that would have been created in the Al-Rawi camp, which has been described by the United Nations as a place of horror and terror. Our citizens and their descendants have been exposed to extremism in the most radical way, Mr. President, in ways that we don't quite imagine or understand here, and therefore there is a need to treat with them. Does the DNA law by itself contribute to that? Perhaps. You have material and evidence of what your DNA says. DNA is very useful. DNA is used in its most basic concept in evidence for crimes, to trace victims, to treat with closure, to find fathers who are missing, mothers who are missing, to establish paternity, maternity, death. There are all sorts of ways in which DNA is well reputed to be working well. But Mr. President, to pluck the concept of returnee and just simply say take DNA in the face of the Mutual Assistance in Criminal Matters orders as to the Republic of Iraq, Belgium, which is the transit point for foreign terrorist fighters returning to Trinidad and Tobago, and the UAE, Mr. President, is to try to stick our heads in the sand and say, we are doing the best that we can, and let's hope it doesn't happen. Mr. President, I have a very real fear that foreign terrorist fighters will return to this country, and for that reason, I consider that the constitutionality of the passage of this law is all the much more important, because when we are challenged as a state for having taken DNA without consent, when the DNA legislation was passed with a 3/5 majority, Mr. President, because of its constitutional ramifications, Mr. President, when we passed the amendments, 2018 many times, 2019, 2020, 2024, all of those amendments were with 3/5 majority. I was back then the chief advocate of the proportionality rule from Lady Hale in Surat, so upheld in Suraj. It was the opposition, now government, that made a mockery of that, saying that that was rubbish. In fact, the case of Suraj was lost by their former Attorney General, Mr. Anand Ram Logan, and the Privy Council upheld my point of view on Surat. So, Mr. President, even though I was the advocate for Surat, we still passed the law with a 3/5 majority, because we were dealing with the concept of the danger to Trinidad and Tobago in having persons who were exposed to violent extremism return to our jurisdiction.
Mr. President, I rise and stand under 53(1)(b). I think the Senator has already made that point several times now. Thank you.
Yeah, I'll sustain that, and you could press on.
Point made. Apparently by me. Thank you, Mr. President. So, Mr. President, today we're engaged in a farce, a legislative farce. A small bill turns up. Don't worry about it, man. Trust us.
Softly piloted.
Softly piloted by somebody who I was shocked to see piloting the law. Not that he's not capable, the Honorable Senator, but I was quite surprised to see the Honorable Senator piloting the law. And when we looked to the law that was piloted, it's like, yeah, don't worry now. It's an administrative clawback to anti-terrorism. That don't mean nothing. Trust the minister to just say you are the subject of his view that you are a problem as a foreign terrorist fighter, not so labeled as an FTF, because you can only be deemed to be an FTF if the law is applied and you're convicted. So you can't be a foreign terrorist fighter. But who the minister with responsibility for anti-terrorism has reasonable grounds to believe poses a threat or risk of committing a terrorist act and who is not a foreign terrorist fighter. Mr. President, I can't play that charade today. This is too important an issue to pluck it out of one law where it made sense, the concept of a returnee, and to just drop it in the DNA legislation. It's going to be challenged. And when it is challenged, Mr. President, the last thing Trinidad and Tobago want to know is that you get off on a technicality. The last thing we want to know is that. The last thing we want to know is that somebody's going to challenge the taking of their samples, etc., and a big hurrah comes. But, Mr. President, it's more than that. You want to make sure that people who are innocent bystanders in the concept of financing are not caught into the web, Mr. President. People who provide zakat, people who give charity, etc. Mr. President, I hold the view that this law should at the minimum be amended to include a preamble which requires a 3/5 majority. The definition of a foreign terrorist fighter at paragraph B cannot stand as it is because there is no process until it has reached the stage where you're challenging later that the minister didn't have reasonable grounds to suspect you, so the damage is done already. Your DNA sample is already in the custody, your biological sample. The European Court held in the case of MAPA versus the United Kingdom, and it's still the leading case, that is unconstitutional. In the MAPA case, it was an entire chamber. It was 15 judges of the European Court that held that, Mr. President. Not 3, not 2, not 1. 15 judges of the European Court, Mr. President. But today, we're to accept the minister's say-so. Mr. President, this is dangerous. The people of Trinidad and Tobago need to be very well aware. I note that there's apparently support for the law. Everybody's entitled to their own views, and I say that with the greatest of respect. The context within which this law is being piloted is devoid of comparison. There is a need for temporary exclusion orders. There is a need to corral violent extremism, to receive people who are coming into our territory who fit the 130 people who have been exposed to radical, criminal, terrorist behavior. They need to be put into a safe management system where they are received by the Republic of Trinidad and Tobago. We have just broadened the rights to citizenship by law. You can claim citizenship through your grandparents. You can claim citizenship by way of being once removed as a descendant. Mr. President, the net is wider. The key is to have PVE, Preventative Violent Extremism Management. The DNA law was merely a corollary to the Returnees Bill 2022. It was a consequential amendment. And the Returnees Bill 2022 was drafted with a 3/5 majority, Mr. President. Mr. President, the government will have its say. They have the majority in this parliament, Mr. President. They're afraid of the things that we have to see. That's debate. That's opposition and government. But, Mr. President, I think that the only last thing that I need to see, some members of this House would do very well to go and get a DNA test and to give rights to people who have none.
Mr. President,
I end, Mr.
offensive,
President.
irrelevant, please. We're going today.
I end, Mr. President, by saying everybody has a right under DNA. Under this law, it must be scrutinized and protected, and they certainly have rights as children who are abandoned by their parents. I thank you.
Anybody else? Anybody else? Anybody else? Leader of government business?
Mr. President, I thank you. I am reading the room, and I want to thank everyone for their contributions this morning, this afternoon. And the impression I have gotten is that there seems to be broad support for what we are doing, but there's an issue with respect to Clause 3B, which is a clause that speaks to the minister borrowing the definition of foreign terrorist fighter to deem a person a foreign terrorism fighter for the purposes of the DNA legislation, to take a non-invasive sample. And we appreciate, I want to place on record that we appreciate Senator Murray's observations, as we always do. I think it was one of the most sensible contributions from that side. Because I don't think anybody else wants to speak. I mean, in descending order, let me deal with Senator Boodhu's contribution. There's some points I want to look at. He said fair is not the architecture of governance, but we say, Mr. President, that security and safety is the architecture of governance. He's talking about lack of judicial oversight, and that is something that Senator Al-Rawi spoke about as well. But I want to say again, and maybe it wasn't said clearly enough, or I would excuse Senator Boodhu's. No, I'm not going to say that. He spoke about judicial authorities, but he didn't come here with any. I didn't hear any from him. But I want to tell him that if you look at the case of Adrian McLeod, you look at all these other cases that talk about protection of the law. Protection of the law includes the right of access to a court for the vindication of your rights. And there's another principle of legislative drafting and statutory interpretation that says that you cannot oust the jurisdiction of the High Court except by clear and express words. Nothing in the bill ousts the jurisdiction of the High Court in its jurisdiction for judicial review. And certainly nothing has, and injunctive relief, of course, and nothing in this bill has ousted the jurisdiction of the High Court. Its original jurisdiction under this Constitution of Trinidad and Tobago, Section 14, for constitutional relief. So there is the right of access to a court. Senator Boodhu, you hinted on some, your words were that there was jurisprudence about DNA and its importance of private information. I didn't hear it. He didn't tell me what the jurisprudence was. Senator Al-Rawi gave us a case from the Supreme Court, United States. In the same way in downstairs, well, not downstairs, we say in the other place. Strasbourg jurisprudence. So last week it was Strasbourg downstairs. This week it's Markle or something? No, that's Strasbourg. That's Strasbourg. Yeah. But he's talking about a U.S. matter. the UK matter, okay? Went to Strasbourg. So it's the same thing that Mr. Scotland MP spoke about. But we're not in, at the end of the day, the Privy Council is our final court, and all courts are bound. The principle of stare decisis. We are not bound by Strasbourg. And it's not even persuasive, Mr. President. The lawyers will know what we're speaking about. It's not even persuasive. We're not bound by that jurisprudence. And to bring it out here is in my respectful view, to detract from the issues. Now, Senator Boodhu, I want to deal with some of your submissions and some of your arguments. I think you had some interesting arguments. And as I said, I'm dealing with the the interesting ones, the ones that are worthy of being dealt with. You spoke about the police as the determination. The police should be the determinating agency and not the minister to deem you as a foreign terrorist fighter. But I'm sure you would understand that the minister who is designated Minister of Defense used to be the Minister of National Security. The minister, as far as Senator Al-Rawi said, who is within the architecture of the Anti-Terrorism Act, the minister with responsibility for national security, is the minister or the functionary under our system who has the intelligence, the information. He will have links using his office under treaties, under arrangements, under the mutual assistance, under all of these settled arrangements that we've had with our friends overseas. He would be engaged with the heads of the protective services, the Army, the Coast Guard, the police, and so on. And he's also a member of the National Security Council. So it makes sense to have that functionary make the assessment, as opposed to a court, when you need to do it very quickly, because everyone knows and everyone should appreciate that courts are ill-equipped to make assessments of matters of national security, or to make quick assessments. But I think Senator Boodhu, at some point, and I think he conceded, because he may have prepared his contribution along the lines of what happened downstairs, to say that deeming meant that you were deemed a terrorist under the Anti-Terrorism Act. So he very quickly changed it, and I respect him for that. And I respect him for conceding. And he tried something very disingenuous, in my view, and he said, yes, but it would affect the reputation of the person. Be that as it may, we thank you for your concession, that it has nothing to do with the Anti-Terrorism Act and deeming anybody under there. It has become a pattern sometimes, Mr. Speaker, over the last session, that we always end up with a recitation, of invocation of Surat and Suraj and Surat and Suraj, and maybe in today being the last day of school, we had to have it again. So we had it. Senator Al-Rawi spoke about it. And at the end of the day, we have a difference of views. We are not a court of law.
But he claimed it as his victory, and that was a 2007 judgment.
Well, he claimed it as his victory, but he also claimed that he was advocate for Surat. I don't know if he meant, certainly was an advocate in. I was involved in Surat as one of the lawyers. I can't remember him being an advocate in that case. But maybe he meant advocate for the case as opposed to advocate in. Okay, so I'm correct. I am correct. I'm hearing something, but Mr. President. But, Mr. President, we will say it again. And again, I don't want to keep us all back, because we are not a court of law. We have put forward our reasons why we say we are within, and we say that the provisions, the very provisions we have here in this bill fall within the spectrum of permitted incursions, permitted and proportionate incursions, as Lady Hale has said, in Surat. That spectrum, incursions and fundamental rights, for that we do not require a special majority in this case. So it's a difference of opinion once more. So with respect to Senator Al-Rawi, we don't agree. We don't agree with your proposal for amendment, which you're probably typing up now. We have until midnight when, in the Cinderella moment, this session disappears. We could stay here all night. So it's a good thing it's 2 clauses and not 18, right? But we don't agree with your proposal that we should amend to have a preamble. And we don't agree with your signaling that we should amend the definition of foreign terrorist fighter. Mr. President, through you, I want to tell the good senator that this is a bill we're dealing with. It's not a witness statement. And we don't want your track changes all over the world. Please, keep your blue ink on your side with your colleague over there. Keep your blue ink on your side with your colleague over there to do all your thing, right? Please. I will move on, Mr. President. I dropped my red pen to use my blue pen. And with those few words, Mr. President, I beg to move.
Honorable Senators, the question is that a bill entitled an Act to amend the administration of justice, Deoxyribonucleic acid bill, Chapter 534, be now read a second time. Those in favor say aye. Those again say no. I think the ayes have it.
A bill entitled An Act to Amend the Administration of Justice, Deoxyribonucleic Acid Act, Chapter 534.
Leader of Government Business.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Administration of Justice Deoxyribonucleic Acid Amendment Bill 2026 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the Administration of Justice DNA Bill 2026 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those again say no. I think the ayes have it. The Senate shall now go into Committee of the Whole to consider the bill clause by clause. Honorable Senators, we have 4 clauses in the bill. All right, so we have 4 clauses in the bill, and then we have some new clauses proposed by both Senator Dr. Desirée Murray and Senator Faris Al-Rawi, SC. Now, new clauses would come after we deal with the clauses contained in the bill. So, since we have no amendments to the 4 clauses in the bill, we will deal with those 4 clauses collectively, right? No. Two, right, in the amendment circulated by Senator Faris Al-Rawi. We have an amendment.
Yes,
So we'll go with the first 2 clauses. There's an amendment to clause 3.
Clauses 1 to 2.
The question is that clauses 1 to 2 stand part of the bill.
Mr. President, Mr. Chairman.
Do you have any amendments or clauses?
Yes, Mr. Chairman. In my circulated amendments to clause 2,
Wait, just
for your guidance.
No, you remember you have an amendment to clause. You have a new clause 2, am I right?
Well, I'd like your guidance if you just...
So we deal with new clauses after.
Oh, mine is not labeled new clause. I just want your guidance.
Submitted as an amendment. It can't go into clause 2. It is not interpretation. It has to be treated as an
Clause 2 cannot be treated as any amendment to clause 2. It is a new clause, so it will have
Sure,
to be taken
I'll be guided by
separately.
you.
Okay? So, as I said, we will go with clauses 1 to 2.
Clauses 1 to 2.
The question is that clauses 1 to 2 stand part of the bill. The question is that clauses 1 to 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Senator Faris Al-Rawi, SC.
Thank you, Mr. Chairman. Mr. Chairman, I propose that clause 3, as it specifically relates to Part B of the proposed amendment to the section of the DNA Act, be amended so that it is not the minister with responsibility for the Anti-Terrorism Act having reasonable grounds to believe a person causes a threat or risk, but instead that it will be, Mr. President, a court on an ex parte application has ordered. Now, the reason why I have suggested that, Mr. President, is that having the benefit of advanced passenger information now part of our laws, we know who's coming. Having persons who are applying or as being entitled to citizenship in Trinidad and Tobago, we have advance notice of who's coming. Having Mutual Assistance in Criminal Matters Act under the hand of the Attorney General for the Republic of Iraq means we have advance knowledge of exactly who's coming. So therefore, there's more than adequate time to knock on the door of the court, exactly as we do for Section 22B of the Anti-Terrorism Act, where listings for the purposes are done ex parte before a judge. That way, it is a judicial officer ex parte on affidavit, exactly like Section 22B of the Anti-Terrorism Act prevails, that allows this very special high-risk category of person, a returnee, Mr. President, to come to the attention of law enforcement. This would radically transform the bill and provide a safeguard, Mr. President. Radically. Because, Mr. President, the fact is that if you don't go the route of returnee, you still have the Immigration Act where you can treat with a desirable person or undesirable person under Section 8 of the Immigration Act, which would allow you to detain the person and take the DNA sample under the existing 3/5 majority law. So this is an easy passage out for the government to save this law and pass it, Mr. President, with due constitutional safeguard. Those are my submissions.
Yeah, Attorney General, can you,
Yes,
on
Mr.
the leader of our business?
Mr. Chairman, we've heard what Senator Al-Rawi has said, especially when he talks about radical departure, and we agree that what we have proposed here is not a radical departure from the powers under the existing Immigration Act. It's nothing new. It's nothing new for what a Minister of National Security or a Minister of Defense can do under the law as the appropriate person or body to do it, the functionary. We've been advised by the technocrats, Mr. Chairman, that this bill does not need a special majority, that there is the protection of the law, that giving the minister this power is proportionate, and this power is proportionate, and it pursues a very legitimate aim, and in the circumstances is appropriate, and we are not prepared to accept the Senator's amendment.
All right. Any further interventions? Okay. The question is that Clause 3 be amended as circulated by Senator Faris Al-Rawi, SC. Those in favor say aye. Aye. Those against say no. No. Division.
Mr. Allahar?
No.
Mr. Jeremy, SC?
No.
Mr. Roberts?
No.
Dr. Swarat Singh?
No.
Mr. Maraj?
No.
Mr. Alexander?
No.
Mr. Ratiram?
No.
Professor Prasad?
No.
Dr. Chaitan Maraj?
No.
Mr. Beg?
No.
Ms. Charles?
No.
Mr. Zakur?
No.
Mr. Smith?
No.
Mr. Nakid?
No.
Mr. Jack?
No.
Dr. Brown?
Yes.
Mr. Al-Rawi, SC?
Yes.
Mrs. Roberts Rajman?
Yes.
Mr. Dan Paul?
Yes.
Mrs. John Bates?
Yes.
Mr. Boodhu?
Yes.
Ms. Choate, SC?
No.
Dr. Atz?
No.
Mr. De La Bastide, SC?
Yes.
Ms. Joan Simmons?
No.
Mr. Lewis?
No.
Dr. Murray?
Yes.
Mrs. Lalit Etienne?
Yes.
Mr. McNish? No. Ms. Phillips?
Yes.
10, 20. Mr. Chair, the result of the division is as follows. 10 senators voted for, 20 senators voted against, and there were no abstentions.
Honorable members, the result of the division is as follows. 10 members voted for the amendment, 20 members voted against the amendment, and there were no abstentions. The amendment is not carried. Okay. The question is that clause 3 stand part of the bill. The question is that clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. The question is that clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stand part of the bill.
New clause 2.
Yes.
By Senator
Mr. President, for the purposes for your management, I'm prepared to withdraw my new clause 2 because Senator Murray has the exact clause. So to save the committee's time, I'd be very pleased to withdraw mine, but I do stand behind the one that will come from her.
Is that new clause 2 be read a second time? Those in favor say aye. Those against say no. The noes have it. Division, okay.
Mr. Allahar.
No.
Mr. Jeremy SC.
No.
Mr. Roberts.
No.
Dr. Swarat Singh.
No.
Mr. Maraj.
No.
Mr. Alexander.
No.
Mr. Ratiram.
No.
Professor Prasad.
No.
Dr. Chaitan Maraj.
No.
Mr. Beg.
No.
Ms. Charles.
No.
Mr. Zakur.
No.
Mr. Smith.
No.
Mr. Nakid.
No.
Mr. Jack. Dr. Brown.
Yes.
Mr. Al-Rawi SC.
Yes.
Mrs. Roberts Rajman.
Yes.
Mr. Dan Paul.
Yes.
Mrs. John Bates.
Yes.
Mr. Boodhu.
Yes.
Ms. Sophia Choate SC.
No.
Dr. Atz.
No.
Mr. De La Bastide SC.
No.
Miss June Simmons.
No.
Mr. Lewis.
No.
Dr. Murray.
Yes.
Mrs. Lalit Etienne.
No.
Mr. McNish.
Abstain.
Miss Phillips.
Yes.
Mr. Chair, the result of the division is as follows. 21 senators voted against, 8 senators voted for, 21 senators voted against, and there was 1 abstention.
Honorable Senators, the result of the division is as follows. 8 senators voted for the new clause. 21 senators voted against the new clause, and there was only 1 abstention. The clause is not, the new clause is not carried.
Not be read a second time.
And not be read a second time.
Mr. President, Mr. Chairman,
Yes.
having
Yes.
regard to the last vote and the fact that the new clause 2 was not allowed, I'm wondering if Senator Murray, through you, would want to proceed with a proposal for the preamble. Let's not be academic.
No, no, it's a question that he's raising. Senator, go ahead. You want to? Senator Dr. Desirée Murray, a question is being put to you.
Thank you, Mr. Chairman. Through you, I noticed that Senator Al-Rawi has the same preamble, so I will defer to his.
He withdrew.
He withdrew.
You carry for him. He withdrew.
Withdrawn in favor of you.
He withdrew. You carry for him. What is your story?
Well, being an academic, I see the value in academia, so I'll proceed with the academic exercise.
New preamble.
What's your question?
The question is that the new preamble be read a second.
The question is that the new preamble be read a second time. Those in favor say aye.
Aye.
Those against say no. No. A division.
Mr. Allahar?
No.
Mr. Jeremy Essie?
No.
Mr. Roberts?
No.
Dr. Swarat Singh?
No.
Mr. Maraj?
No.
Mr. Alexander?
No.
Mr. Ratiram?
No.
Professor Prasad?
No.
Dr. Chaitan Maraj?
No.
Mr. Big?
No.
Ms. Childs?
No.
Mr. Zakur?
No.
Mr. Smith?
No.
Mr. Nakid?
No.
Mr. Jack?
No.
Dr. Brown?
Yes.
Mr. Al-Rawi SC?
Yes.
Mrs. Roberts Rajman?
Yes.
Mr. Dan Paul?
Yes.
Mrs. John Bates?
Yes.
Mr. Boodhu?
Yes.
Ms. Chode SC?
No.
Dr. Atz?
No.
Mr. De Labastide SC?
No.
Ms. Joan Simmons?
No.
Mr. Lewis?
No.
Dr. Murray?
Yes.
Mrs. Lily Etienne?
No.
Mr. McNish?
No.
Ms. Phillips?
No.
Mr. Chair, the result of the division is as follows. 7 senators voted for, 23 senators voted against, and there were no abstentions.
Honorable Senators, the result of the division is as follows. 7 members voted for, 23 members voted against, and there were no abstentions. The preamble to the new preamble will not be read a second time. Any other thing? Honorable Senators, the question is that the bill be now reported to the House, to the Senate that is. Those in favor say aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. The leader of government business.
Mr. President, I wish to report that the Administration of Justice Deoxyribonucleic Acid Amendment Bill 2026 was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, The question is that a bill entitled an act to amend the administration of justice Honorable Senators, the question is that the Senate agree with the committee's report on the administration of justice, DNA Bill 2026. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Leader of Government Business.
Mr. President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Deoxyribonucleic Acid Act, Chapter 534, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice, DNA Act Chapter 534, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. No. Division.
Mr. Allahar?
Yes.
Mr. Jeremy SC?
Yes.
Mr. Roberts?
Yes.
Dr. Swarat Singh?
Yes.
Mr. Maharaj?
Yes.
Mr. Alexander?
Yes.
Mr. Ratiram?
Yes.
Professor Prasad?
Yes.
Dr. Chaitan Maharaj?
Yes.
Mr. Beg?
Yes.
Ms. Charles?
Yes.
Mr. Zakur?
Yes.
Mr. Smith?
Yes.
Mr. Naked?
Yes.
Mr. Jack?
Yes.
Dr. Brown?
No.
Mr. Al-Rawi SC?
No.
Mrs. Roberts Rajman?
No.
Mr. Dan Paul?
No.
Mrs. John Bates?
No.
Mr. Boodhu?
No.
Ms. Chot SC?
Yes.
Dr. Atz?
Yes.
Mr. De La Bastide SC?
No.
Ms. Jones Simmons?
Yes.
Mr. Lewis?
Yes.
Dr. Murray?
Yes.
Mrs. Lalit Etienne?
Yes.
Mr. McNish?
Yes.
Ms. Phillips?
Yes.
Is as follows. 23 members voted for, 7 members voted against, and no members abstained from voting.
Honorable Senators, the result of the division is as follows. 23 members voted for the bill. There were 7 members voting against the bill, and there were no abstentions. The bill is passed by majority. The Leader of Government.
A bill entitled An Act to Amend the Administration of Justice, Deoxyribonucleic Acid Act, Chapter 534.
The Leader of Government Business.
Mr. President, I beg to move that this Senate do now adjourn to a date to be fixed.
Honorable Senators, before moving to have this Senate adjourned, all of us would be aware that we would not be back in time to celebrate Indian Arrival Day. And we also have Corpus Christi coming up as well. So we will now invite honorable senators to bring greetings on the occasion of Indian Arrival Day, which is supposed to be celebrated on May the 30th. I recognize Senator the Honorable Prakash Prasad.
Thank you, Mr. President, for allowing me the opportunity to bring greetings on the 181st anniversary of the arrival of East Indians to this country of ours. So I start by saying, Mr. President, Namaste, Salam, Abhivadan, Vanakkam, greetings in the languages of Hindi, Urdu, Bengali, and Tamil respectively, from where our ancestors came. In 1845, Mr. President, on the 30th of May, the vessel named the Fatal Razak, and some people say the Fatal Razak, and I think that would be a fatal mistake to call the Fatal Razak Fatal Razak. Fatal Razak came to the shore and brought 225 indented laborers from India to the shores. Mr. President, this date of arrival was declared a holiday in 1994, May 30th. In 1995, it was renamed Indian Arrival Day, and in 1996, it was declared a holiday permanently in the sense that it became Indian Arrival Day, such that those who hadn't quite arrived at the right understanding would not change the name again to Arrival Day. Over the period 1845 to 1917, 147,592 indented laborers were brought to the shores to assist in reviving the economy of Trinidad and Tobago. They were sent to the sugar plantations in Trinidad and in Tobago also. So they came, Mr. President, with a very, very meager belongings. The local term is Jahaji bundle, a very small package with tangibles. But intangibles, they brought their culture, their beliefs, and their lifestyle attitudes. They came from the modern-day UP. Uttar Pradesh then was the United Provinces, from Bihar and the south of India, mainly from Tamil Nadu. In fact, Mr. President, the ancestors of our Honorable Prime Minister, Mrs. Kamala Prasad Bisesa, SC, is from the northern state of Bihar. On a personal note, Mr. President, my paternal grandfather, my Dadaji, Pandit Pateshwar Tiwari, came to these shores in 1906, and he also was from Uttar Pradesh, United Provinces, northern India. Mr. President, India was an ancient and proud civilization, at least 5,000 years old. It gave the world fundamental concepts and theories in mathematics, astronomy, amongst other subjects. It was one of the first countries in the world to have a university, a medical university. History bears that out. So it was a well-developed civilization, well-planned cities, etc. in Mohenjo-Daro. It was also one of the major economic powers together with China. They dominated the world economy, India and China. That's why everybody, the Europeans in particular, were trying to go to India. But, Mr. President, like all proud civilizations, like all civilizations, they rise and they decay, and they decayed. So Vijay Surajpal Naipaul, a son of Trinidad and Tobago, and the Nobel laureate said that India was a wounded civilization in a book so named. So when they fell under this sort of state of decay, disrepair, they were conquered. And under the latest sort of oppression as such it came was under the colonial rule. It was so oppressive and difficult for Indians that there were huge famines, millions died in the famine, and there was a state of disrepair throughout the country. And therefore, many were seeking to leave the country to find a better life elsewhere. In other words, looking to become economic migrants. So when this indented labor scheme, and Mr. President, I use the word scheme in the colloquial sense, a scheme, was presented to them, many of them chose to come to what was called Chindidad. Chindi means Hindi for sugar, the land of sugar. They didn't say land of sugar and honey, the land of sugar. So many were induced to come to Trinidad. So in effect, Mr. President, they were economic migrants. And when they came here, they were subjected to a brutal and heartless labor regime in the plantations. But, Mr. President, as I noted before, as an ancient civilization, the people of India were characterized by an ethos of hard work, strong family bonds, culture, and a desire for self-improvement and a reverence for the land of their birth. These are all bases for having productive, patriotic citizens. Furthermore, their culture formed a central part of their life, and the ethos of this culture was of tolerance and also of living in diversity. And if you look at the history of India, Mr. President, there was always a cultural, this sort of diversity in India, a tolerance for different cultures, for different points of view. And that is a central ethos of, people who came from India, in India, and those who came from India. So, Mr. President, coming to this country with nothing really in terms of physical, assets, they came here and worked hard upon the completion of the bonded service. Some went back to India, majority stayed here. Those who remained, following their cultural ethos, their civilization ethos, worked hard to better their own lives, live themselves by their own bootstraps, and to ensure that a better future was there for the children through education and micro-entrepreneurship within a culture of national development. So, Mr. President, the descendants have carried out their ancestors' dreams and values, have all contributed to national development in most fields of endeavor, if not all. In culture, we have Brikijai as a Calypso monarch, junior Calypso monarch. You have Jit Samaru, one of the top pan organizers in the country. We also have Drupati, the famous singer, and of late, the irrepressible Rasika Dinduyal, with the famous chutney, Pongdi Damadol. Mr. President, I wouldn't go into the others, other fields that entered and excelled. But I would just say that in terms of governance, they also worked in that also. An outstanding example in that regard is former President Nur Hassan Ali, former President Bazir Pandey, and former Prime Minister Bazir Pandey, and present Prime Minister, the Honorable Kamal Prasad Bisesa. So it is clear, Mr. President, that the cohort of indented laborers and descendants got integrated fully into the national community. They are part of the national community now and part of national life. I mean, Mr. President, how can you think of Trinidad without doubles? That came from that sort of culture. Now, I refer to a Calypso Jahaji Bhai by one Brother Marvin. So he was a man, is an iconic Calypso and a man of a broader vision. And this Calypso alluded to the fact that we all are brothers of the boat. Translated, Mr. President, Trinidad is like a boat. A boat is surrounded by water. Trinidad and Tobago is surrounded by water. In other words, we are a boat grounded, or a boat in the ocean. We either sink together or we float together. We all are family. And therefore, this idea that came, and is part of our national watchwords and also our national anthem, every creed and race find an equal place, production, discipline, and tolerance. These are part of the values that we came with and also is part of the national culture. So therefore, in regard and respect to Brother Marvin, Mr. President, I would like to say to the entire national community, Happy Indian Arrival Day. Dhanyabad. I thank you, sir.
Senator Faris, Al-Rawi, a seat.
Thank you, Mr. President. Very good to hear from the learned professor, the Honorable Senator Professor. Not often we hear his voice. Happy to hear it. Mr. President, we on the opposition bench join in offering our congratulations to the Republic of Trinidad and Tobago on Indian Arrival Day. It's been a journey to get here. What is it in a name that we celebrate today? We certainly don't celebrate only that 35.4% of our country has its roots in India. Today we're celebrating Trinidad and Tobago's recognition of a portion of our society, a cherished portion of our society's journey across the Kalapani, the Death Waters, to come to Trinidad and Tobago and to choose to stay here, to contribute, to become Trinidadians and Tobagonians by stint, by effort, by determination and participation. I don't share the view that it is the fatal razak. That would be to not understand the meaning of that vessel. That vessel was made in Europe, bought by a Muslim merchant and named Fatah al-Razak, which in Arabic, Fatah comes from the root to open or purvey or to give or to grant. And Al-Razak is one of the 99 names of God. And in those 99 names of God, we're celebrating the gift and glory and the opening and the purveying of this benefit to the people of Trinidad and Tobago. In many senses, Mr. President, you'd probably think that the vessel was appropriately named, Mr. President, associated with the name of Allah the Almighty, Ar-Razak, and associated with Al-Fatah in the opening and purveyance. So, Mr. President, I think it's important to reflect upon meaning. Meaning in origin, meaning in dedication, Mr. President. I understand that struggle of coming from different roots. My mother is Indo-Trinidadian, my father is Iraqi. That meeting of cultures, that place where women in Middle Eastern culture don't take husbands' names because they're not chattel or property. You continue in your own path. And I remember my grandfather telling me always that names have meaning. And this Indian Arrival Day for us, I think, has an explanation as to why we wanted to perhaps call it Arrival Day, because all of us arrived in some form or fashion. Whether we came here as the plantation aspect of our history, whether we came here in the horrible conditions of slavery or indentureship, because indentureship, Mr. President, associated itself with our Chinese population, our Portuguese population. Many of us have suffered the indignities of that label and that attachment and that struggle, Mr. President, to become proud patriots of our country. So, Mr. President, we too on the opposition bench wish Trinidad and Tobago, not our motherland, wherever that part may be for each of us in our respective ways, we wish Trinidad and Tobago a happy Indian Arrival Day as we celebrate becoming a part and parcel of this beloved nation. Thank you, Mr. President.
Thank you, Mr. President. To my colleagues in this honorable chamber, and indeed to all of Trinidad and Tobago, on this observance of Indian Arrival Day, we honor not only a journey across oceans, but a journey across generations. Since 1994, Trinidad and Tobago has commemorated Indian Arrival Day on May 30th, a day on which we remember the courage of those men, women, and children who arrived on these shores carrying little in material possessions, but bringing with them something far more enduring: resilience, faith, discipline, culture, and hope. From the cane fields to the classrooms, from small shops to boardrooms, from temples and mosques to parliament and public service, the labor and sacrifice of our East Indian brothers and sisters have helped to shape the Trinidad and Tobago we know today. Indian Arrival Day is not simply a commemoration of arrival, it is a reflection on endurance. It reminds us that nation building is often carried on the backs of ordinary people who quietly persevere through hardship, exclusion, and uncertainty, while still believing in the possibility of a better future for their children. Indian Arrival Day commemorates the arrival of our ancestors aboard the Fateh al-Razak in 1845, the first ship to bring Indian indentured laborers to these shores. Those who traveled together on that long and uncertain voyage, men, women, children from different regions, from different religions, from different castes and backgrounds, became bound together not simply by circumstance, but by shared hardship, survival, and hope. The indentureship experience also gave rise to what has often been described as, and as Professor Prakash Prasad shared with us, as a Jahaji Bai spirit, a profound brotherhood born not out of blood, but of shared struggle, shared sacrifice, and resilience. A spirit immortalized by Brother Marvin in his 1996 Calypso classic, Jahaji Bai. Together with all those who came to these shores and those who were here long before, they helped weave the rich and enduring fabric of our Trinidad and Tobago identity, binding us together as one people, forged, as our national anthem says, from the love of liberty. As a nation, we must continue to draw wisdom from that legacy. In a time when societies everywhere are grappling with division, with economic anxiety, and social fragmentation, the story of Indian arrival teaches us the value of community, of family, of education, of enterprise, and cultural pride rooted in mutual respect. But this day of commemoration also invites us to reflect on the unfinished work of nationhood. The strength of Trinidad and Tobago has always rested on its diversity. Not diversity merely tolerated, but diversity embraced and woven into a shared national identity. So as we celebrate Indian Arrival Day, let us recommit ourselves to building a society where every citizen feels seen, valued, and afforded dignity and opportunity. A society where our differences are not exploited for division, but embraced as part of the rich human tapestry that defines us. May we honor the struggles of the Indian ancestors who came to these shores, not only with ceremonies and greetings, but by the kind of nation we choose to build together. On behalf of the Independent Bench, Mr. President, I wish you and your family, and I wish everyone in this chamber and the people of Trinidad and Tobago, happy Indian Arrival Day. Thank you, Mr. President.
Honorable Senators, I rise and join with other senators on this occasion on behalf of the Senate of the Republic of Trinidad and Tobago to extend warmest greetings on the impending observance of Indian Arrival Day on the 30th of May, 2026. This year marks the 181st anniversary of Indian Arrival Day in Trinidad and Tobago. In other words, honorable senators, 181 years ago, the vessel Fatel Razak entered the Gulf of Paria, carrying the first of hundreds of thousands of Indians who would journey to these shores in search of survival, opportunity, and dignity. Though they arrived under the harsh realities and further indignities of indentureship, they endured with resilience, perseverance, and faith. Through sacrifice and steadfast determination, our Indian brothers and sisters laid foundations not only for their families, but also for the development of our nation. They persevered, and in persevering, they gave our cherished nation an extraordinary gift. Today, the contributions and traditions of the Indo-Trinidadian and Tobagonian community are deeply woven into the fabric of the Trinidad and Tobago national identity. Their influence resonates through our music, cuisine, literature, spirituality, agriculture, commerce, education, and public life. In the field of national development, the legacy of those arrivals continues to enrich and strengthen our society. Indian Arrival Day, however, is not only a celebration of achievement, it is also a moment of fervent reflection. It calls upon us to acknowledge the hardships endured by those who came before us and to recommit ourselves to the ideals of equality, justice, and mutual respect. It reminds us that the strength of Trinidad and Tobago has always rested in the ability of its people to build together whilst honoring the distinct traditions that shape our collective identity. In the spirit of solidarity, honorable senators, on behalf of the Senate, my family, and the staff of the Office of the Parliament of the Republic of Trinidad and Tobago, I extend sincere greetings to the Indo-Trinidad and Tobago community and to the people of Trinidad and Tobago. May this observance inspire continued unity, understanding, and national pride as we move forward together as one people and one nation, ever going forward and never going backward. I thank you. Honorable Senators, we now proceed to Corpus Christi observance, and I now call on Senator, the Honorable Dr. Kennedy Swartzing.
Mr. President, thank you. I'm honored and humbled to bring greetings to the Christian community on this wonderful feast of Corpus Christi. On the night before he died, Jesus gathered with his apostles to celebrate the ritual of the Passover meal. During this final meal with them, he continued to spread words of love, with the most powerful action being what he did when he took the bread, broke it, and gave it to them, and then took the cup, gave thanks over it, handed it to them to drink. It was no longer bread and wine. It was his own body about to be broken for them, and his blood about to be poured out. In this sacred ritual, Jesus not only embraced his friends with love, but held them close to his heart in one of the greatest sacrifices of all. As our nation's Catholic and other Christian communities look to celebrate the sacred feast of Corpus Christi, we are reminded that some of the most powerful lessons for leadership, governance, and national development are rooted not only in economics, policy, or legislation, but also in values, faith, service to humanity, and indeed sacrifice. Corpus Christi, which means the body of Christ, is more than a religious observance within the Christian tradition. It is a profound symbol of unity, compassion, humility, and shared responsibility. It reminds us that no society can truly prosper unless its people understand that they are connected to one another through common purpose, mutual respect, and collective duty. At its core, Corpus Christi speaks to selfless giving. It commemorates Christ offering himself for the benefit of humanity. In public life, this principle carries immense significance. Leadership cannot merely be about authority, position, or influence. True leadership requires sacrifice, requires placing national interests above personal ambition. It requires listening to the concerns of every citizen, especially the vulnerable, and making decisions not for short-term applause, but for long-term national progress. This is particularly important for us in Trinidad and Tobago at this stage of our national development journey. We are a nation blessed with extraordinary human talent, natural resources, cultural richness, and strategic potential. Understanding this is important because Corpus Christi teaches us that societies flourish when people work together, sacrifice, and share our resources in the spirit of unity. The Eucharist itself symbolizes many becoming one body. In the same way, national development cannot be achieved through division, hostility, or isolation. It requires partnership among government, private sector, labor, faith-based organizations, civil society, and communities. It requires citizens to recognize that nation building is a shared responsibility. In this spirit, this Kamala Prasad Bisesa-led government strives to govern with honesty, fairness, and discipline. We ensure that public resources are used wisely and efficiently. We aim to strengthen our institutions so that they remain resilient, credible, and capable of serving future generations. We work to create systems that reward innovation, merit, and selfless sacrifice while protecting the most vulnerable among us. As we move to join the Christian community's observance of Corpus Christi, let us also recognize the enduring role of faith communities across Trinidad and Tobago. Churches and religious organizations continue to provide spiritual guidance, social support, educational assistance, community outreach, and moral leadership in countless communities. Their contributions to national resilience and social stability deserves recognition and appreciation. In a rapid changing world marked by uncertainty, technological disruptions, geopolitical tensions, and economic transformation, nations require more than policy frameworks. They require values that anchor decision-making and inspire collective purpose. Corpus Christi offers such a lesson. It calls to unity over division, service over self-interest, compassion over indifference, integrity over expediency, and hope over despair. The Feast of Corpus Christi requires works of love more than words of love. As citizens of this great twin island nation, let us embrace this principle and continue to take this country higher. On behalf of the government of the Republic of Trinidad and Tobago, and on behalf of our bench, Mr. President, I extend sincere greetings to all observing Corpus Christi across our country. May this sacred occasion inspire renewed commitment to service, national unity, ethical leadership, and sustainable development. I thank you.
Senator Vishnu Danpon.
Thank you, Mr. President. And as usual, it's good to see you again. Mr. President, this is one of my favorite acts in this honorable house, no pun intended. Mr. President, thank you for the opportunity to extend greetings to all citizens of the Republic of Trinidad and Tobago as we observe the Feast of Corpus Christi, a solemn and joyful celebration in the Roman Catholic tradition and a recognized public holiday in our nation. Corpus Christi is one of the most prominent holidays in the Catholic Church. It is a holiday of great reverence for the Holy Eucharist, the real presence of our Lord Jesus Christ, body, blood, soul, and divinity, providing a public witness of one's belief through both liturgical worship and display in the community. Corpus Christi, as my colleague said, meaning the body of Christ in Latin, commemorates the institution of the Holy Eucharist. In Trinidad and Tobago, it stands as a testament to the rich Catholic heritage that forms a vital thread in the tapestry of our diverse national identity. At the heart of Corpus Christi is the celebration of the true presence of Jesus Christ in the Eucharist and the commemoration of the establishment of the Holy Mass. The belief that the bread and wine consecrated during Mass become the actual body and blood of Christ while retaining their physical appearances stands as a central tenet of the Catholic faith. Mr. President, our nation is proudly pluralistic, a confluence of faiths, cultures, and traditions. It is a source of national pride that we honor and respect the sacred observances of all our communities. In doing so, we reaffirm the values of mutual respect, unity, and fellowship that bind us together as one people. On this day, I extend sincerest greetings to the Catholic community, to all Christian faithful, and indeed to all citizens across this Twin Island Republic. May this occasion renew a spirit of gratitude, compassion, and solidarity among us, values that are essential as we continue to build a stronger, more just, and more harmonious Trinidad and Tobago. May God bless our nation. Thank you, Mr. President.
Senator Candace Jones-Simmons.
Thank you, Mr. President, for recognizing me. It is with great respect and warm regard that I rise today to bring sincere greetings to the Roman Catholic community and all who observe the Feast of Corpus Christi and to reflect on this occasion and what it means to the people of our beloved Republic of Trinidad and Tobago. At the heart of Corpus Christi, the feast of the body of Christ, are words from the Gospel of John, where our Lord declares, "I am the living bread, which has come down from heaven. Anyone who eats this bread will live forever." For the faithful, this is not an abstract proclamation. It is an invitation into living a personal relationship with Christ, one that nourishes not only the spirit, but it compels those who receive it to go outward and share love and be in service to others. This spirit of unity and communion is perhaps nowhere more beautifully captured than in the beloved hymn, a favorite of mine, "One Bread, One Body," a song that reminds us that though we are many scattered across the breadth of the earth, we are called into one body, sharing one cup of blessing. It's a message that speaks well beyond the walls of any church, and in a nation as beautifully diverse as ours, the call to recognize our shared humanity, to see one another not just in difference, but to see the belonging, is a message that we don't only need to hear, but we need to live. Now, this celebration is rooted in our colonial history, when the French Catholic settlers, seeking to preserve their faith and identity under British governance, negotiated to have this feast celebrated and recognized. So what began as a historical concession is now part of the cultural and spiritual fabric of our island. What makes this observance particularly distinctive is its deep connection to land. For generations, farmers and gardeners throughout Trinidad and Tobago have held on to this belief that anything planted on Corpus Christi Day will thrive and it will bear good fruits. Rain or shine, they take to their gardens with their seeds and their seedlings and hope in their hands. There's a quiet poetry in that. You see, the Eucharist, Mr. President, itself speaks of bread, of grain, surrendered to the earth, dying and rising again, as sustenance for life. When people carry that same faith into their gardens on Corpus Christi, they participate in one of the oldest human stories, that patient, faithful tendering to the earth yields rewards in abundance. Mr. President, we in the Senate are fully aware of the challenges our nation continues to face: crime that wounds our communities, economic strain that weighs on our households, and at times fracturing of the social bonds that hold us together. In these times, it is worth pausing to consider what the values at the heart of this feast have to offer. And I recall the words of the late Archbishop Emeritus Edward Gilbert, where he reminded us that the Eucharist provides food for the journey and common values. Those who are nourished by this feast are called to charitable works, to care for the poor, and to build up communities. These are not peripheral values. They are precisely what a nation in need of healing most requires. And I quote from our current reigning Calypso monarch: "Trinidad need a blessing, Tobago need a blessing, Trinbago need a blessing, amen." To all who observe this ancient and meaningful feast in the churches, processions, and gardens of our twin island nation, I extend the warmest of greetings. May the values it embodies, gratitude, humility, generosity, and solidarity, find new expression in the lives of our citizens and in the work of those entrusted to serve them. Like the seed faithfully placed in the earth on Corpus Christi, may the good within us take root, weather every storm, and in due season yield a harvest of peace, justice, and flourishing for all the people of Trinidad and Tobago. I wish you all a happy Corpus Christi, and may God bless our nation.
Thank you. Honorable Senators, allow me to join in bringing greetings on the occasion of the Feast of Corpus Christi. As the Christian community throughout Trinidad and Tobago observes this sacred feast, I extend warm greetings and best wishes to all. Corpus Christi, the feast of the body of Christ, occupies a deeply significant place within the Christian calendar. It is a celebration of faith, devotion, and thanksgiving, centered on an enduring belief in Christ's abiding presence among his people. Yet beyond ceremony and observance, this feast calls on us to embody the very values that Christ taught: compassion, sacrifice, humility, service, and love for one another. At its heart, Corpus Christi reminds us that no society can truly flourish unless it is anchored in care for the vulnerable, respect for human dignity, and a commitment to the common good. In a world increasingly marked by division and uncertainty, this sacred observance challenges us to look beyond ourselves and to reaffirm our responsibility to one another as members of one national family. That message resonates profoundly in our Trinidad and Tobago, enriched by many faiths, cultures, and traditions, yet united by a shared aspiration for peace, justice, and understanding. As this Parliament prepares to conclude the first session and enter a brief interregnum, the observance of Corpus Christi also affords us an opportunity for reflection on our service, our stewardship, and our continuing duty to the people of our beloved nation. My sincerest wish is that this occasion inspire in all of us a renewed spirit of compassion, integrity, and unity toward the collective good. On behalf of the staff of the Parliament of the Republic of Trinidad and Tobago on my own behalf and that of my family, I extend best wishes to all for a blessed and peaceful Corpus Christi. May God continue to bless our beloved nation, and let us together build one another. Brothers and sisters, ladies and gentlemen, the question is that this Senate do now adjourn to a date to be fixed. Those in favor say aye. Those against say no. This Senate now stands adjourned to a date to be fixed.